my God, that was so cute. Thank you. Isaac, okay, my bad. I apologize. My bad. Nothing, honey. We just got started. Hello, classy lady. Classes keep fogging up. Listen, I've been on grandma duty, okay, today. Running ragged. I'm tired. I'm old. Hello, Tanya. Hello, everyone. Okay, let me get this all pulled up. Also, Wavy texted, or not, he didn't text me. Calm down. I'm not India, okay? Calm down. He messaged me, he DM'd me on, what's this called? On TikTok today. And sent me Germany, Ireland. Oh my God, what did I say? Listen, I just be renaming folks, okay? Her name's India. From now on, her name's India. She's not getting today, okay? She's not getting... Fucking sakes. God damn it. Well, she's India now. We're just calling her India, okay? But she doesn't get today. The fuck is this? Anywho, Wavy messaged me all the text messages that she's been sending to him yesterday and today. I put India in the story again. Oh my God. I can't with myself. I can't. Today I did? Oh my God, how embarrassing. He's like, look, I just want to let you know, she's still texting me saying, can we still be friends? Can we still... I haven't even read them yet because, again, I never read anything until I'm here with my people. I can't believe I did that again. Listen, it's St. Patrick's Day, okay? So I'm just not giving her that time. Did I not? What's happening? What the fuck is this? I'm not going back to work. Oh, here we go. The transcript. Okay, let me see if I can figure out, because it's a link. Let me see if I can figure out how to open it. You all know I'm technically challenged, okay? Hey, Jeff K. Amy, hello, love. Did you ask him why he hasn't blocked her? I did. I absolutely did, Angie. I sure did. And I will go over all of that. But I know you guys are here for the transcript, so we'll start with that and then we'll end with that. But I absolutely 100% did. And why he doesn't just send the phone back. I did. I told you her elevator. Yeah, her elevator's stuck in the basement. Mm-hmm. Sure did. It's the what's the thing outside? The drain pipe outside. And it's dripping onto my my patio. And it's annoying the shit out of me. I have to fix it. But anyways, I haven't had time. It just started today. It's driving me crazy. Okay. Accept all. Okay. Okay, I got it, Bailey. Do you got it? Are we all here? Do you guys have this? Was asking earlier if we have done our reading yet. Was he? Listen. I will forever write hard for 2K. Okay? 2K is an amazing young man who has really helped other men reach out to me to help just even be able to see their kids. And he is an amazing father, and I will forever write for him. So, yeah. Okay. Miss Bailey, my amazing, amazing reader.
Hi.
Here, got the popcorn ready. I love it. I'm here for it. Make sure you guys get your snacks. Send this out to anybody who wants to. Because listen, once we get started, we don't go back. Then you'll have to watch it over on the YT, which I'm here for. Nope, we haven't started yet. Okay, thank you, Kathy. And the way that this goes, hey, Jay Shell, is I'm the judge. So I will read all of the judge's stuff and the witness stuff, right? Bailey?
Yeah.
Okay, so I read the judge and the witness stuff, and she will read the attorney's parts, okay? So, and we'll always say what part we're reading, because we're reading verbatim, word for word. There's going to be times where we... Rhonda! Thank you! There's going to be times where it's going to sound like we're stuttering. We just read verbatim, word for word. We add in the pauses. You are getting exactly what it is in here. I always get messages after. How come you keep stumbling on this or whatever? That's why. Thank you, Rhonda. Also, if you guys aren't already following, make sure you guys follow. If you haven't seen a daily harmony, please send a daily harmony. That's all I ask. The tappers and the yappers. Thank you guys for all of the yes, this is the January 6th transcript. Thank you for everybody who gives. I apologize if I miss it while I'm reading because I keep my head down, but I never want to not thank you. So thank you in advance.
Also, when I go through and I bounce between the attorneys, I'll say John's attorney and Bree's attorney so it doesn't get confusing.
Perfect. You're the best. And all of these up are all of these are up on my YT as well. Maybe I should make like a list. Oh my god. I just said that. Now people are gonna want it. I would have to figure that out. Okay, I spoke too soon. I'll see if I can figure out how to make like a list, and then you will see them all in there. I may need help. Okay, are we ready?
Yep.
Okay. I say that, and then mine goes away. Okay, so it says assigned for all purposes. Declaration of Respondents Counsel are lodging court reporters. Certified 1626 transcript. Thank you guys so much. What the hell? You guys are freaking amazing. How many pages in it? You know what? I have no idea.
109.
Why did you ask? Why'd you do that? That's right. Get ready. I'm glad I went back out and got my cup. Okay, 109. Buckle up, bitches. Get comfy. We're going in. Okay, let's see. The first part is always just saying she's Lindsay and she's doing this pursuant to whatever. We routinely lodge transcripts and other documents by the way of notice of lodging pleadings with transcripts and documents attached. However, the clerk's office is erroneously rejecting our notice of lodging the transcripts and documents. I find this funny. She says this every single time. Do you know who has never had to do it this way? Taylor. Due to the above issues, I hereby lodge the following documents via my declaration, and it's the court certified transcript. Exhibit A, here is the certified transcript from January 6th. Let me get to the right page. Okay, here we are. So I'm starting out as a judge. We are on the record in the Giese versus Olson matter. I will give you the case number in a second. Let me have appearances, please.
John's attorney. Good afternoon. Taylor Budnick for the petitioner, John Giese. He is present via LA Court Connect. Then Bree's attorney. Good afternoon, Your Honor. Lindsay Fonseca for Brianna Lynn Olson, respondent who is present next to me at counsel table.
The judge. Okay. And the case number is whatever. And I appreciate everyone's patience. The court had a very busy calendar this morning, so I wanted to give this case the attention it deserves and to make sure we had enough time. So thank you for coming back this afternoon. The court has to make an indication first before we get started. The court received an email to not my court email address, not my personal email address. It's another email address from somebody who I don't know. I didn't read it. I saw the first two lines and it looked like they were talking about this case. I will print it out. It was an attempt at an ex parte communication. The court disregarded it, and I will read it at the time. I should have printed it out before. I just want to let everybody know, but I was a little surprised, but just so you all know, the court does feel it has a requirement to disclose an ex parte communication. I didn't get past the first line, and it certainly won't implicate my ability to be fair or impartial in this case, okay? So the parties were coming back and forth, and I just want to make sure Ms. Fonseca knew what Ms. Budnick was saying. And I don't know if you've spoken. Ouch. But one, Ms. Budnick made a passing reference to wanting to have an evidentiary hearing. Is that correct?
And John's attorney, it is. I think, and I would like to be heard, I think on the issue of sort of where we are at. the status of the custody arrangement. I do think that it's important for the court to receive that update today.
Okay.
And then John's attorney, the concern that I have with an evidentiary hearing is what I understand based on my conversations with Ms. Fonseca, pleadings that were served on my office yesterday at 8 p.m. and the New Year's Eve at like 4 o'clock is that Ms. Olson is planning to rebut the Family Code 3044 presumption. And so,
Sorry. Then the judge, you know what, Miss Budnick, hold on a second. I'm having a really difficult time hearing you. I didn't know if it's, yeah, there's some feedback.
then Bree's attorney, I think it's her headphone mic, but now the computer mic sounds maybe worse.
Try it again.
Then John's attorney, I had headphones in, so perhaps that was the issue.
Much better.
Then John's attorney, okay, so what I was saying was, to my understanding, then Bree's attorney, Your Honor.
Hold on. There's another phone number appearing.
Then Bree's attorney, these are probably random strangers that want to watch this case.
I'm going to cut in here really fast. Don't do that shit. You guys, I know you, listen, Sock Gang, I know we would never, but anyone else who may see this or whatever, don't do that. Please don't go to their court. Please don't try to call in and watch that stuff, please. That's so beyond disrespectful. Nothing, love. We just got started. Okay, so anyways, now I'm back to the judge. That was Angie. Now back to the judge. Okay, all right. There is a court policy that anybody who logs onto Court Connection has to be affiliated with this case in some respect. So the number, okay, seems to be our new normal today. Go ahead, Miss Budnick. So disrespectful.
And Miss Budnick, John's attorney, sure. So what I was saying was I do want to update the court on the custody orders and how some things have been going. I think that it's important for the court to receive that update. I was served with pleadings filed by Miss Olson on New Year's Eve and then yesterday evening at 8 o'clock. And so it is my understanding based on those pleadings, and again, I had 2 court days to look at them, one of them not even a day to look at the other, so I've skimmed them. In that, Ms. Olson is planning to try to rebut the Family Code 3044 presumption. And my understanding of 3044 is that it is her burden to do that. My concern is that if we proceed with an evidentiary hearing on her request right now, I'm not prepared to oppose it because I just got served with the pleadings. I do have relevant witnesses that will address factors in 3044 as just an offer of proof. There have been issues of noncompliance by Ms. Olson with the custody's order made in connection with the DVRO, specifically with regards to Santos being present for visits, and with respect to exercising the visits in Dallas and surrounding counties. My office filed an ex parte, which I understand was denied back in October. That does set forth some of the issues that have been going on. There have been subsequent issues. My office served formal discovery on Ms. Fonseca's office to try to gather evidence for an evidentiary hearing on the issue of her rebutting the 3044 presumption and the larger issue of custody and the move away. And these other sort of prejudgment issues in the parenting case. We received no response whatsoever. I have a motion to compel on calendar for February 9th. So on top of the very late filings by Ms. Olson, it didn't give me enough time to put my case together to oppose her positions. There also necessary discovery that we do not have yet. And so I would ask the court to set an evidentiary hearing for some time after February 9th, probably 30 days thereafter. So that will give Ms. Olson time to provide the documents that we've asked for. In that, we can put on our evidence. The issue, I think, and from my conversations via email with Ms. Fonseca, is that the court did indicate on August 27th that you would have hearing in January for the purpose of allowing the respondent to put on all of her proof as to the 3044 issue, whether that is rebutted or not. She mentioned doing a parenting class. So I think part of the issue, I don't want to necessarily fault Ms. Fonseca, their new date by which she needed to provide her evidence. And so the problem now is I got it right before a holiday and a weekend reality. And then, just so your honor is aware, to highlight, I know the ex parte that we filed in October sets forth concern as to, the existed as of October. That existed as of October. We have evidence that the respondent removed the minor child in December over Christmas to San Antonio, Texas, which is over 4 hours
Bailey.
away
I'm
from
sorry, Bailey. Hold on. User, you can either get the records yourself or you can go watch it somewhere else, but what you're not going to do is be disrespectful at all. This is 107 or 109 pages of documents in court lingo. Do not be disrespectful. If you don't like it, you can absolutely go somewhere else. Bailey, I apologize. You were doing a fucking fabulous job. Keep reading. Thank you. Sorry.
Oh, thanks. I'm a Leo, so things don't really upset me very easy. But thank you.
You know how I am over here. We gonna keep it cute, or you can be muted. Listen, you can get the documents yourself. Okay, move along. Sorry.
Well, and it's hard because you get confused in your brain because, like, one of the words didn't make sense in that spot at all. But that was the word.
And again, we're reading it, and I said this in the beginning. We're reading this word for word. They start talking about something. They switch it up. Anyways, and then real quick, because I was going to say this when you're done. Also, for those of you guys coming in asking how much you guys have missed, nothing. We're just in we're like the second or third page. Yeah, she'll get blocked if she speaks again. Mods will handle that. Okay, I apologize. I just wanted to address that. Thank you, Bailey.
No, you're good. It is not a surrounding county of Dallas, and she left the minor child alone in the care of Santos's relatives. She wasn't even there, and so there are pretty serious violations of the order that were issued on August 27th. Among the other factors, there is additional DV as is a factor for the court to consider.
The judge. Wait, hold on.
Then John's attorney, thank you.
The judge. Additional DV has, not that I'm encouraging or soliciting one, but has a request for a DV restraining order been filed?
Then John's attorney. So my reading, and I could be wrong on this, but I'll let the court help me. My read on 3044 is the additional acts of DV element to this is not necessarily in relation to DV between Mr. Giese and Mrs. Olson. Miss Olson. It could be Miss Olson's
preparation.
There you go, preparation of DV as to other individuals. And we have seen evidence and we have an understanding. And again, our formal discovery was designed to gather evidence on this issue that Miss Olson has perpetrated DV with regard to her current partner, Santos. Hold on 1 second. Give me a hug. I love you. Sleep good. Turn off all the lights, please. No, turn it off.
Yes, guys, these are brand new, and they just dropped today. It's a transcript from January 6th.
And they are in and actively or very frequently a DV relationship, which I think triggers not stating the restraining order, that could trigger the 3044 presumption, or the issues with respect to giving Miss Olson custody, because children have a right to be free from abuse in their household. And she has made it very clear she's living with this man. She's very, very adamant from the pleadings I skimmed that he be present for all of her visits. We have really serious concerns with him, and the discovery, again, is designed to help us get evidence. I also have, once we're set for a date, again, I didn't have time to pull all of this together in light of the filing. And the issue that happened over Christmas is just so recently in time. We have officers that will testify as to where the minor child was found and with whom.
The judge was found and was what? I missed the last thing.
With, and then John's attorney, with whom?
The judge. The police? Okay. I'm going to let you respond to all of this, Miss Fonseca. But you said the police. So is that in relation to what you're alluding to, potential domestic violence involving Miss Olson and her partner?
Then John's attorney, no. So that's a different issue. One of the other elements of 3044 is compliance with the, is there a restraining order? Is there a restraining order, and have the terms been complied with? This would be evidence that it has been complied with. The order includes a restriction on Ms. Olson's ability to travel outside of Dallas and the surrounding counties. It also includes a prohibition on Santos being present for visits. Ms. Olson also communicated with my client that W would be at one location. He received evidence that he was somewhere else, not in Dallas or surrounding counties. A welfare check occurred, and the officers did find W at a location in San Antonio.
The judge. So it's in response to a welfare check.
And John's attorney, exactly.
Judge. Okay. All right. I'm not making any findings or representation. We're really just dealing with sort of the procedural posture of this case. Specifically, Ms. Budnick's request that Ms. Olson's request to rebut the presumption be adjudicated in a more formal evidentiary hearing. So if you want to respond to that.
Then Bree's attorney. So, as I told counsel via email, over the break, here in LA County, we don't show up to RFO hearings or status conferences and treat them as setting hearings. As I know is common in Orange County, where she was practicing before she recently changed firms to a Bay Area firm. Specifically, at the very end of our trial on the 27th of August, you said we're going to come back in 6 months because under 3044, there is a presumption against joint legal and joint physical, and you can overcome that presumption with certain things. DV, which I don't think is appropriate here, but parenting classes is. And so, if you come back and show me your parenting class, the court may very well consider changing the presumption. And then you went into reading the rest of your orders. So, if counsel forgot that this was the purpose of today's hearing, as specifically said by the court, we've served and lodged this transcript months ago, when we filed and served our December 31st supplemental declaration, which again in LA County is common to do.
The judge. Hold on. I'm going to stop you. I don't need to be difficult. Just a couple of things. I don't do in RE judge down the hall, or I don't do, in LA County. I evaluate the law. Every judge is an island on themselves. So it's what's before me. So that's not helpful, okay? So I just want to stick to what the facts and the code and the law requires, as opposed to what's custom in practice in LA County.
Then Bree's attorney. Okay, so when we did our supplemental pleading to update the court on everything that has occurred since we last saw you in August and serve that on the 31st, if counsel had forgotten that this was the purpose of today's hearing, pursuant to the transcript, we quoted the transcript, bolded that portion in the declaration of the transcript, and gave references, meaning citations to the lines and pages and page numbers that we were talking about, not just as to the purpose of today's hearing, but also to the parenting class. Because in the transcript, also while the court was giving its orders at the end of that August hearing, the court said that John was going to be ordered to do a class separately of Brianna. To our knowledge, he has never completed that parenting class. Brianna invited him to do it with her back in April, which we detailed before we even stepped into the trial in her supplemental pleading from July the 23rd. She invited him to do it with her. He said no. He claimed he had already done one and had filed a certificate. We never were filed and served with one. So she did a private class with Scott, and I think you pronounce his last name blank. He's the owner of one of the facilities on the LA County's approved list. She did a 12 class private by Zoom with the facility owner. High conflict co-parenting class. She completed it on the 20th of June. We lodged and served that certificate on July the 3rd. We included another, conversation or reminder about it in our supplemental pleading of July 23rd before the trial commenced. And then when this came up in the very last few minutes, if the court recalls, we were very rushed as you were giving your orders because it was end of day. I spoke up and said, well, she's already done one of those classes. Would that count? And the court said, I'm not going to make her do it again. Miss Budnick, what say you? And she said, I'm not sure about the specifics of the class, but I assume if it's the line with what the court's ordered, I wouldn't object to it. So, at the time she made those comments in August, she already had the class certificate for almost 2 months. As soon as we left court, I immediately reached out to her on the 2nd of September and attempted to meet and confer. Hey, I spoke with the owner myself. This is the format of the class. Here's the facility's information. It's on the approved list for LA County Superior Court. What say you? I don't know why she was saying, what say you?
I don't know.
I'll look into it. Thanks. Then I followed up again on the 17th of September. Hey, never got a substantive response. What say you about this class? Are you going to object to it? We went around in circles about this and some other topics, and eventually she just said, I'm not having this conversation anymore. I'll take up my objections with the court. And so we filed and served this supplemental pleading again to update you on everything that has occurred since we saw you over 6 months ago. And there is another reminder. Hey, Miss Budnick, we still haven't heard from you about this. If you're going to lodge objections to this class and wait to do it in the courtroom when I've tried to meet and confer with you multiple times, that seems like a bad faith approach to what should be a very simplistic yes or no question. Because I started asking as soon as we left the court to give my client ample opportunity to take another class if Miss Budnick was for some reason going to object to the one that she already took. That our position is, of course, that it meets the court's requirements that were ordered. And as to this angle on discovery, I also anticipated this argument. If the court wanted to know specifically what the discovery was about, it was not about 3044. It was about my client's travel documents. Does she have any intention to relocate outside of LA County? Who traveling with her to visit? Who traveling with her to visitations? The only topic on there about 3044 is the one that asked for her co-parenting class documents. And as I told Miss Budnick, she knows from, I'm sure, other clients having to take these classes, all they get is a certificate. I don't know what other materials she would expect my client to produce. We have already produced a certificate to her and the court 2 or 3 times over. So the discovery, contrary to what her presentations were 10 minutes ago, was not about 3044. So that's not a basis for this continuance. We filed a supplemental declaration to update the court and provide our position as to why 3044 has been overcome. As I also told Ms. Budnick in my email yesterday, these documents we were going to share with her in person. The stack of stuff I have here for the court and for her and John. We didn't know until we came and checked in this morning that there weren't going to be here. So I feel like that kind of feeds into this strategy of let's not file anything. Let's not come to court so we can delay and the inevitable from happening. What the fuck? And I will say, to Ms. Budnick's credit, we routinely appear remotely in this case to save money for both parties. And her and I always email each other when we're going to appear remotely. We've never messed with the forms. It's just an informal email. Hey, we're going to appear remote in case you guys want to as well. In this particular day, this is the only hearing where we got no advance notice that her and her client would not be in person. And even if she had given us notice, I would have told my client, this is an important hearing. We should come in person for this one. And especially because we were bringing these medical records about my client's pregnancy, about information I will not discuss on record, but was willing to show Miss Budnick and the court in chambers as to my client's medical records. And so she knew we had the lease, which we also did not want to go public. So my client's new address, we have the lease for her today. We have the medical records for her to review today. And again, we had no notice that she wasn't going to be here. So this all just feels like not like a last minute thing, but like a planned strategy to try to bump today's hearing and then put it on the basis of we serve discovery pursuant to, factors of the 3044 list, when the discovery has nothing to do with those factors. The discovery, in fact, was about very detailed and otherwise private information that we wanted about my client's travels before the September visitation, which the court knows was our first try at unsupervised visits after we left the courtroom following trial. And I told Miss Budnick, where in the orders are you basing this off of? We've already given you the address. The parties have already met and conferred as to the dates that they're going to do the visits. So where are you basing these requests off of? And she gave some reference to a particular page of the DV packet, and I said, Miss Budnick, that is not what those orders say. And then she said, and this is in the emails that I filed with our supplemental declaration, She said, "Before you attack John about this, know that this is me. I'm concerned about my professional liability to my client if something is to happen to the child while he is in your client's care." Then I said, why are we reading the emails to the judge? Like, I just don't understand, but okay. Then I said, "Well, similar to you guys insisting that my client exercise her visits in the visitation facility, absent a real order ever being made for that, this seems very similar, that you are trying to impose orders on my client that do not exist. And the particular thing that she was asking for as to my client's travel were not in the orders, were not things that we had even discussed as part of the DVRO trial. And she was demanding that we send them to her. When I refused during our meet and confers, 1 hour after those emails stopped, on the 17th of September, she served discovery for the same information. So the discovery has nothing to do with 3044, but about her client wanting to know, I guess, every single little thing there is to know about my client's life and her unsupervised visits with W that was not in the orders, but per Miss Budnick's own admission via email was more of her, I guess, in position as a professional, concerned about her client, I guess, would hold her liable for. And I suggest that maybe she talk to her client about that in private, because that seems more like an attorney-client relationship issue. But it's not something that she could use to impose non-existent orders on my client. So when we got the discovery, I gave her my client's old lease that's now since expired. She's in a new place, but I gave her that. And she's right. We objected to the other stuff.
The judge, hold on. I am not dealing with the motion to compel.
Hold on, let me take a quick drink.
Good. This is a lot of. If you want, I can see if someone else wants to come up. Maybe principal wants to come up and read one of the attorneys, because it is a lot of attorney talking. You're doing both. So if you want me to, let me know. I'll see if someone can. But if not, you can continue.
I don't care either way if someone wants to read another attorney, because I don't think there is any witnesses. I think it's just the attorneys going back and forth with the judge.
Oh, is it? Or if not, maybe I can do. If that's what it is, then I can do one attorney. I
Yeah,
can
I
do
think
that.
it's
Okay,
just...
I'll do the judge and one attorney.
Okay.
You're on Miss Fonseca. Okay, so I'll do John's attorney then. Okay.
Okay. Hold on. What page are we on?
Page 17. You're on the okay, line 24.
Okay. So then Bree's attorney. Okay, I understand that, but she kind of made... Hold on, let me restart. Okay, I understand that, but she kind of made that the basis of her argument. So I just want to make sure that I was well heard on the discovery not being about the 3044.
The judge. Okay, so your position is, and to the extent that your position is, her argument that we needed an evidentiary hearing or more time because she needs additional information. That is that's in the discovery request that would be relevant to the 3044. And you're saying the information she's seeking is not relevant to your client's efforts to rebuke the 3044.
The Bree's attorney. Correct. And this hearing has been set for 6 months. And again, using a quote that I put in there earlier from the 827 transcript, it was specifically set for this. So she's had 6 months of opportunity to file pleadings to say why Brianna has not overcome the 3044 presumption, but didn't do so. And like she said, there is no deadlines on that. We both know if it's a supplemental pleading that there's more or less a made up pleading that we're using just to update the court on everything that's occurred since we last saw you. But we last saw you 6 months ago. And again, if it was forgotten that this was the purpose of the hearing,
The judge, counsel.
we highlighted that in the New Year's Eve pleading.
Judge, respectfully, you've got to stop with the forgot. Remember, the court started with, I didn't feel like I needed to set ground rules again because I've done it in every hearing, but I'm going to do it again. Let's stop with the, she may have forgotten. They said this. That's snarky. Let's keep it in the facts because we don't have a lot of time. And part of the reason we don't have a lot of time, frankly, and we're always in a rush, is because our time, I think, was wasted with personal attacks towards each other and a lot of the undue consumption of the court's time. Despite multiple efforts, I told both of you that the things I was looking for, that this wasn't a defamation case, yet we saw hours and hours of videos and texts and things that really, it sounded to me like neither party was really paying attention to what the court was saying. So, I just want to clarify a few things. Yes, we were rushed. I don't think that's on the court. I think it's because both parties didn't follow the court's directive. And I appreciate it. I didn't mean to. You had a great flow and I didn't mean to interrupt, but let's stop with the if she forgot because that's snarky and I think you both are much better attorneys than that. So go ahead, last word, and then.
Yeah, last word is just there is no just cause for a continuance. If we're here for the 3044 and to decide if the class that my client took met the court's requirements, I made very good faith efforts multiple times to try to confer with counsel about that and kind of just had the door shut in my face. So here we are. And again, I will be willing to give these documents to the court if if it's just the people that we know in here, we could just not even have to go into chambers if you wanted to discuss the pregnancy stuff. But I won't do that on record.
The judge. Okay. Well, a couple of things. I do want Miss Budnick to respond. I agree with you 100%. I really do, as it relates to notice and anticipation in preparation of today's hearing in terms of rebutting the presumption that was based solely on the class. I think we've all been on notice of that from the beginning of the hearings. Miss Olson has indicated which class she was taking. And in fact, I think that's why the court made the comment that it did, that if it's something she's already taken, I will give her credit. So we were all on notice about that. I agree with you. But one of the things I heard from Ms. Budnick, we have to go through all the factors of the 3044, is a reference to, and I don't know when it happened and where it happened. I don't know how relatively new it is or not, and I haven't seen any evidence. My sense is of allegations of domestic violence, potentially between Miss Olson and somebody else. I don't know, but she made reference to it. That's different. That's something that is potentially a new development. And frankly, is something the court might take into account. Oh, yikes. Anyway, sorry. Focus. Look, I'm going to be frank one of the big issues that has been ongoing in this request before was whether or not Miss Olsen's new partner, who I understand is the father of her current child, cannot be around W. And the court at the time during the hearing, mostly because the court's finding regarding her partner's involvement in, I think, the circumstances of how much the court ultimately granted the DV restraining order. Is participation in that, and whether it was her endorsement, her encouragement, and her knowledge of that. And also, I guess there was that one video regarding the diss track and a reference to that, and W being in the video when her partner was talking about making a diss track of Mr. Gacy. That's why the court at that time made that temporary order. Now, obviously, I understand that is going to be a renewed request. I think it's in her pleadings for the court to alleviate that, especially since W is going to need to be with, should be with his half sibling, and should the father of that half sibling be present. So obviously that's something a request to the court will and would have probably today seriously considered. The court's concern, obviously, is there are allegations of domestic violence between those two individuals. That's something that the court should consider in the terms of the 3044. Not only in terms of the 304 process, but also in terms of ruling on Ms. Olsen's request that I lift the prohibition and the ban against her new partner from being around W during visitation. And they are all kind of interrelated. So I agree with you 100% as it relates to the class. And I think that could have been anticipated. And if that was the only issue, I would agree with you, Ms. Fonseca, that there is no reason we shouldn't go forward today. I'll be frank, the other issues were of more concern to this court. If they are true, I don't know.
Then Bree's attorney, and I guess that's my struggle. I agree with you. For those are true, then there's a concern, but counsel just brought all of that to the surface in this moment, even though there was 6 months to file. So unless she said this happened yesterday, or happened, I don't know, I mean, at any time outside of the business day that wasn't yesterday, it should have been brought before the court, not via counsel's testimony, but via those officers they claim that can testify. Via any pleading they could have served the last 6 months. So I think it's rather unjust to my client, who has been, from our perspective, doing what she's supposed to have been doing pursuant to the court's orders the last 6 months, and came in with the materials to share with the court and opposing counsel, materials which could have been attached as exhibits. But, we don't want to expose her lease, her new address, to social media. These things in these specific documents also protect, for example, a third-party Airbnb host, random strangers that claimed they were reaching out on John's behalf. On behalf of John, I messed that up. Sorry. Messaged the host of her rental back in the November visit, trying to get videos from the visit, talking a bunch of smack about Brianna to the owners. So that person's name in the Airbnb messages between her and my client is part of this packet, which we didn't want in the public file for obvious reasons. So we came in fully prepared to move this forward in the way that we thought the court was very clear about. The purpose of today being. Instead, it feels like we're kind of being sabotaged. Man, I am struggling to read today. Instead, it feels like we were kind of being sandbagged with new information, which again, unless it happened last night, this information should have been put before the court before right now.
John's attorney, if I can respond, the judge, okay, go ahead, Miss Budnick.
And Bree's attorney, to all of that.
The judge, yes. Miss Budnick, so John's attorney, sorry. So first, with regards to the first concern about Miss Olson's violation to the order in the sense of Santos being present for the visit, we did file an ex parte to try to address that issue. You filed a response. That was on October 21st. I understand from the court's position it wasn't a life or death immediate emergency, but the issues were set forth in that motion, as was the issue of domestic violence between Santos and Miss Olson. I will let the court know that in one instance that we are aware of, there are more. We also apprised the court and respondent as to the issue of Miss Olson telling Mr. Giese W wasn't staying at one location, and then evidence coming out that she had appeared to be at an undisclosed hotel, refusing to tell Mr. Giese, the custodial parent, where the child was. We then, as of Christmas, so a week ago, 10 days ago, we found out that W was in San Antonio, not Dallas. It's not a surrounding county of Dallas. In the case of Santos's family members without Miss Olson present. Oh my God. I just got a report from law enforcement. I have not had time to issue subpoenas. I was waiting on the report to make sure that it was worth subpoenaing out-of-state officers to testify at a hearing. The discovery, to touch on the point of the discovery, one of the demands is a demand for law enforcement records by Miss Olson. We've also asked for verification on where she has been. That speaks to the 304 issue on if the DV-130 and the attached custody orders are being complied with or not. We have reason to believe that she is telling Mr. Giese she is in one location with W and actually spending time at another location. This is relevant because part of the issue that led to the restraining order filing was Miss Olson at this point had twice removed W from the state when she was supposed to be exercising visits. So there is a very serious concern that if she's able to now travel to Los Angeles or further restrictions are lifted, that Mr. Giese, the custodial parent, will have no idea where his child was. And that is particularly concerning when we have reason to believe, and I've seen videos of Miss Olson in what appears to be mutually abusive relationship. On top of that, I agree with the court that the issue of the 3044 and rebutting that presumption is not as straightforward as, here, I did a class. Anybody can sit through a course and complete a course and get credit for course completion. The issue that I expressed with to Miss Fonseca months ago was the day that Miss Olson completed the course was June 20th, 2025. There was testimony by Miss Olson during the restraining order hearing that on June 21st, 2025, she was laughing about sending Santos or going with Santos to a hotel to try to threaten John. So my position is, I don't think, even if that course itself is satisfactory, I think there is an issue of, did the course resonate? Did she take anything away from the course? And the 3044 is a serious statute, right? It's important. It protects children from perpetrators of abuse. And I think there is a very real concern that Miss Olsen still has not learned anything. And even the pleadings that I skimmed, and part of my issue and request for setting this for an evidentiary hearing date in the future is that it is Miss Olsen's burden to rebut the 304.4 presumption. Up until December 31st, she has filed nothing to try to rebut that presumption. And so, for my purpose, coming into today, there wasn't much evidence to put on. There was no report to rebut the presumption. I understand, counsel, and I had disclosed a class. But again, a class alone, completion is not sufficient to rebut this presumption. I think it is a very, very real concern that requires testimony and evidence on accountability by Miss Olsen. And I think restraining orders are serious. I think abusive relationships are serious. I think violations of court orders are serious. And to have this very flippant attitude about, well, I did the course, and just so Your Honor is aware, I've seen videos of Miss Olsen live streaming while she is doing the course and asking her followers for the answers and making a mockery of it. And so we will show the court that video. And so it's more than just completion of the course. And I think there is so much more here. There's so many issues, and the accusations that were set forth in the pleadings that were filed at the very last minute, and there's reason I haven't asked to strike those. I would love to cross-examine the respondent on, oh my God, sorry, got excited. I would love to cross-examine the respondent on the statement she made in the declaration she filed on the 31st. As to the statements about remaining in Dallas or surrounding counties with W. She made a comment about how she was not able to travel to Texas because she is afraid if she doesn't have health care in Texas. She left the very next day to go to Paris and was in Paris. So there's just so much. And the discovery, again, I asked for law enforcement records. I asked for, anything related to any impediment of travel, confirmation of lodging, details about who was present with who. We believe Santos has been present for all of those visits. Knowing who has traveled with her, who's been in the Airbnb is relevant. It gives us information on who we can depose, who we can gather more information from. But she is denying it. And I think that we will see that at the evidentiary hearing. She will come up with some kind of excuse to try to justify or minimize what's been happening. Hold on, I gotta do a puzzle. Okay. But what's been happening is for a year now, she's been completely disregarding every single order the court has made. The judge. Okay, I'm going to let you respond. I'm definitely going to let you respond. You said something, and then you went off and said some other things. So I want to revisit that. Part of the reason John's attorney understood the judge. The court indicated, and we had talked about this, and I'm trying to not get too much into your privacy about when the child is due and when there's travel.
Then Bree's attorney, I have that for you.
The judge. Okay, that's fine. When is the baby due? Oh, sorry, Miss Budnick, that's me. Sorry, John's attorney. I will say on record this summer, I will give you the documents. The judge. December. Okay, that's fine. But there are some concerns about her traveling and her ability to travel at some point And that's why we set the hearing for now, because there are concerns about her ability to travel. Ms. Fonseca, I'm sorry. Ms. Budnick just said something about after there were representations about her ability to travel and things like that. That she then went to Paris. Is that correct? Did she? John's attorney. Yeah, she did.
Then Bree's attorney, just so the court is aware, in December of 2025 is when she was in Paris.
The
That
judge.
was 6 days ago.
Yeah. The judge says in December of 2025. Okay. John's attorney. December, late November, or early December. The judge. Look, I'm not a doctor. I'm not an OBGYN. I'm not sure any court order specifically prohibited that. I don't think it did. Obviously, if it didn't, I would want to sort of make considerations in terms of changing the custody and visitation about her increasing potentially inability to travel to Texas. But that's kind of a side note. I'll just put that aside for a second, okay? I want to hear from you, Ms. Fonseca. But again, I'm not sure I want to. There's so many issues here, and I'm to refocus everything and just direct the parties to what the court thinks is relevant. I do agree with Ms. Budnick from the perception of, well, I know 304.4 says whether or not somebody completed a class. I mean, I don't know if you've heard these or heard this before. I've said this in other cases. Just because somebody has a certificate from a class doesn't necessarily mean they took away from what they should have from that class. That's assuming they took the class, because my understanding is that I don't know if excuse me, if it was an order or a suggestion that Mr. Giese take a parenting class. And frankly, I think both these parties should take more parenting classes. I do. I think from what I said, since they came where I think they continue to make some decisions, which I don't know if it's a product of age or a product of this being their first child, but I think there is still room for improvement from a parenting perspective. Balancing that against, look, the reality is they make their living, and they make a good living from their social media, which involves their child, which, as I've indicated, the court is not happy about. But I recognize I don't think at this point I can prohibit, and I also understand it's the source of their living, so I get that. But let me go back to the issue regarding the class and whether or not it was done in a meaningful way. That's one issue. The second issue, I'll be frank, it really is, and I haven't gotten an offer of proof of that. But if there are concerns about domestic violence between her and her new partner, that is probably my number one concern on the court's list. That is number one. So if there is, and I haven't heard any kind of offer of proof, and I know we have an evidentiary, but that is absolutely something the court would want to know about and would want to assess before I made a decision. That's issue one. That has a much higher priority than whether or not she completed a class in a meaningful way, though that is still important. Issues about, was she in Texas? Was she not in Texas? Or where she was? That in and of itself is not as relevant. That in and of itself is not as relevant as others, other than it, if there is. Wait, that's confused me. Sorry. That in and of itself is not as relevant other than if there is, indications that the visitations were not by her, but were by somebody else's family. I mean, again, I understand that that at some point her new partner will be involved in her life. But, and the court recognizes that the reality of it is, if there is indication, I'm not saying it is or it isn't, that there are some wholesome disobedience of the court orders that relates to that previously. It just raises some concerns to this court. Not to punish her, but just sort of the reality of, is she going to comply with the court orders going forward regarding certain things? I mean, everybody knows why we're here. We're here because she used the kidnapping word, and the court never made a finding of kidnapping, but we had to have law enforcement come to where she was staying after a court order and order her to return the child. So there is a history of not obeying the court orders. Very seriously not obeying the court orders. And the court continues to try to weigh everything in this case. The fact that she has a new child and the partner of that child, and to try to accommodate her pregnancy and the travel and all of that. And the court was sort of working through all of that. And then I hear, references, which is undisputed, that I'm trying to accommodate and let her travel. The court made all of these orders, and I'll be frank, I was considering, in light of potential restrictions on her travel, making some visits in California. But then I hear she was in Paris in December, so it's hard. I kind of need to see the whole picture and to put it into perspective to say, yes, she's overcome with burden. When there are these things that, frankly, at least are being presented as a serious concern. I've made no findings, and I don't know if you have an offer of proof regarding allegations of DV between her and her new partner or anyone else. John's attorney. So if the court pulls up our ex parte that was filed in October, there's an Exhibit G. This is just one example, and that's because it was the most recent. This was an incident that occurred on October 11th, 2025. I have attached stills of the video, but I do have the video that I can play for the court at a hearing. You can see Miss Olsen pushing him and shoving him. And I will let you know, the video goes on, and there's quite a bit of that, the judge. And that was filmed? Well, that's a silly question. John's attorney. Exhibit G. Yeah. What I did was I took a screen capture of a video so that the court would get to watch the video, the judge. And was the minor child, was W present? John's attorney. W was not present. But I think the issue is we have had enough of these exchanges or interactions that have either been filmed or we have become aware of, where there is a very significant concern that this is happening so frequently, the minor child might be present if he is allowed to be present for visits, or if she is allowed, more liberalized time. We're also aware of an issue where law enforcement was involved in June of 2025, where in that particular instance, it was Santos who was arrested. There's more evidence, but I don't know that I want to tell the court all of the evidence at this juncture. The judge. Okay, look, I'm not doing the evidentiary hearing now, but I wanted a general offer of proof. If there's something that there, or is this, go ahead, Ms. Fonseca.
The Embree's attorney. Like I told counsel in the meet and confer process on her discovery before she filed her motion a few weeks ago, I paid my dollar to do the name search on both Brianna and Santos for LA County for criminal records. or any other civil case related to DV. Both of their names have no hits. So I told her, I don't know what you are asking us to produce, not just my client, but on a third party, specifically Santos, because it seems like that's what she's asking for. When you can search LA County's records yourself using a name search and or date of birth and see that there's no cases there. There's no records. So I don't know what she's asking to be turned over.
The judge, again, we're not doing the motion to compel today.
Right. As to the class and the mention of, I guess she's alleging that there was a violation of the temporary RO on the 20th of June. If the court recalls that
You cut out. Hold on, you cut out. What we heard, okay, last thing we heard is, I guess there's an allegation that there was a violation of the temporary restraining order of the 20th of June.
If the court recalls...
That's the last thing we heard.
Okay. If the court recalls that specific incident, according to John, and I think the court kind of just drew the connection that we were saying the court drew back at the time of trial. One of the main issues the court took with Santos' involvement as to this piece of John's testimony was that Santos allegedly was outside of his hotel where John was staying, and John was inside and he was scared. And it was Brianna's fault, and Brianna was
orchestrating.
Thank you. Man, I don't know what's going on with me today. Orchestrating it. Well, what we filed with the court last night, but it got rejected, so it's in the system as of this morning. John was actually live streaming from the airport with one of the two buddies. Both of them are named Chris. One of the Chris's that was present at our restraining order trial. They were both physically present. They're both good friends of his. He does business with them. Specifically, this one that he was with is living with John and his mom and W. So him and one of the Chris's were at the airport. They were live streaming. The other Chris calls from somewhere near the hotel saying, I'm trying to get Santos here. He's laughing about it. John is saying, hey, be careful with what you say. We're on live. Laughing about it at the airport. So John's testimony given across 2 days of trial, because if the court remembers, the first day he went through most of his allegations, he had no dates at all.
The judge, wait, hold on. I don't mean to interrupt. I want to refocus us. I'm not really sure your point in all of this. I'm not saying it's not serious. I'm saying what is it? So what is the conclusion I'm supposed to reach? That the 3044 presumption shouldn't even apply because the restraining order was issued in error? If so, then I think you would have to make a request to set aside.
No, not set aside request, not an appeal. This is, and I quoted the court as to what you said on the 27th. If I find evidence of John doing the same things online that he's sitting here complaining about, that will go to his credibility and to his legitimate feelings of fear over these allegations, specifically related to Santos. So we were just bringing to the court's attention that John took the stand across 2 days of trial as to that specific hotel incident. That incident, at least we felt like, seemed to be one of the, I guess we'll call it, golden ticket pieces of evidence that you really considered to be a part of the basis of your granting the restraining order.
The judge, absolutely. So my question to you again, and I'm not trying to be rude, but I'm trying to do this in an organized fashion. To what end are you? Because you just said, I'm not asking you to reconsider the restraining order.
No, correct.
The judge, and to what point? As just a general redirecting of Mr. Giese in his testimony going forward?
Yes, bringing it to your attention because of what you said of wasted about credibility on that particular topic. So to show you that the live stream that he was actually part of and what was said, and the physical violence threats that his two friends, again, one of those friends currently living with him and W, the threats of physical violence that were specifically made during that same incident against Santos by his friends while he was sitting right next to one of them.
The judge. Okay, so again, though your point is, I'm trying to put that to what you're asking of this court. You're asking this court, I think, in your papers, to lift the prohibition against Santos. I'm going to use his first name, no disrespect.
That's his first name.
The judge. Okay. Santos to being around your client and W because to the extent Mr. Giese testified that he was in fear of Santos, that claimed fear is lacking in credibility because of this evidence you brought forward. Is that
Then Bree's attorney, that's one side of it. The other side is because of what Miss Budnick said about the class, that there was this alleged violation that day that she completed the class, because she completed the class on June 20th. So that was to bring light to that comment that Miss Budnick made, and to the comment that made that she's seen videos of my client basically goofing off during the class. Those videos she's referencing are about Our Children First, the mediation class that she took before I was even attorney several months prior. As I told Miss Budnick, and as she could have contacted the facilities, the owner that conducted the class, and confirmed these were private classes taught by the facility's owner, who is a licensed therapist to my client, and my client alone via Zoom. There were 12 lessons at 1 hour each, and then she got a completion certificate with a rating of excellent being the highest of 3 ratings at the end of her class. So I understand that 3044 is not just about the class. I was simply just addressing the comments that counsel made. Another comment that really stuck out to me as her saying that my client was moving W around during her visitations, and she kept saying custodial parent, custodial parent. But my client, the custodial parent, doesn't know where the child was. That was the basis of our dispute in September after we left your courtroom that led her to serving the discovery. So, as she said, my client doesn't know the minute-by-minute location of where W is. Correct. Because these are unsupervised visits. You don't get to micromanage my client's location on a minute-by-minute basis. She was required to provide the address of where she was staying in advance of the visits on Our Family Wizard, which she's done for John every single month well in advance of the visit starting. If she wants to take W to the park or to the mall or to a friend's house, she does not have to tell John each time her and W are getting in the car to go someplace, just like he doesn't have to tell her the same thing. So I took big issue with that part of Miss Budnick's last rebuttal, because that is the main basis of the discovery. Who you're traveling with, who is staying with you, etc. As I told Miss Budnick and explained to my client, and we admitted we don't have anything to hide. Santos is traveling with her when she goes to Texas. There is no order saying that Santos can't do that. Santos is from Texas. He has family and friends there. He has business there. There is nothing wrong with him traveling with her. There's nothing wrong with him staying at the same place as long as it is not during her visitation time with W. That is apparently a different understanding between me and Miss Budnick, because according to what she said via email and just now in her last rebuttal, she believes that John is entitled to minute-by-minute location information, activity information, who is there, what are you doing, about my client's visits. And that's just simply not the case.
The judge. Okay. For the third time, respectfully, this is why our hearing goes on. We're not in motion to compel. This is all about the motion to compel. And I want to go back to what the court said originally. And these are the issues that I think are important to explore more regarding the 3044. Number one, was the class complied with in a meaningful and thoughtful way? Really, that's subordinate to this larger issue, which I think we keep moving away from. I want to move back to whether or not there is proof by a preponderance of the evidence that there has been domestic violence between her and her new partner, because that goes into the very heart of two things. 3044, overcoming that presumption, issue one. But number two, the issue of whether or not this whole issue, which is clear that she wants to lift the prohibition on Santos being present when W is present. And look, I don't have their new child before me. And I don't have W before me. And you know, there were, through the course of the hearing on both parties, and I said it, and I'll say it again, I think there were some not so wise decisions by both parties in this situation in which W was put in. But the one where the court really draws the line is if W is around or exposed to domestic violence again. That causes the court great concern, and that in and of itself alone can cause the 3044 presumption not to be overcome. So I want to really focus on that. I understand your frustration. I understand your concern with the motion to compel. That's for another day. I certainly want to hear those. Those are not before me today. What's before me today? What's before me today? I think she meant I think. And I'm going to go back to is whether or not it makes sense to continue this for an evidentiary hearing and address those issues of domestic violence. Let me just ask you, Ms. Budnick, what do you think is additional that you need more time for in terms of an evidentiary hearing, and why didn't you specifically request it? John's attorney. Okay. John's attorney. So, two reasons. The reason I hadn't specifically requested it yet is because, again, my understanding is it is respondent's burden to rebut the presumption. She didn't file anything arguing that she was trying to rebut it until the 31st. The next day was a holiday. There was a day on Friday. There was a weekend, and then I got served with another declaration. So had I received those declarations from Ms. Olson a month ago or 2 weeks ago, I could have probably put together more today and tried to be ready to go. I do believe that there is evidence we've requested in the discovery that we will receive either responses in form of documents or at a minimum, substantive responses from Ms. Olson saying documents do not exist, which would help me in preparation because I would know what else there is. I would know what else is there and what isn't. I do have police officers that I want to subpoena about the issues of the violation of the order with respect to removing W from Dallas and the surrounding counties, and then where they found him. The reason I did not initially subpoena them is this happened on Christmas. I was out of the office and I was out of town for the holiday. When I got back to the office, we were waiting on receipts of the written police report. I just received that. I wanted to review that before including costs to subpoena officers to come testify at the hearing if they had nothing to offer. I reviewed the report. The report does not confirm what I just represented to the court, and so I do believe these officers have relevant testimony. The other element to this that I think would be very important for everybody is I think Santos should testify. Sorry. And I would love the opportunity to subpoena him to be here to dispose himself. Holly, I love me some Taylor. That part's not in. Sorry, that part's not in there. That was me. My bad. I'm back. I asked for documentation from Miss Olson as to where she's living and with whom. I don't have an address for Santos. I have no idea where he is. We haven't been able to find him. But I would like to have him come and testify to some of the other things that we've seen that are that we are aware of. What we've heard that I think will help us overcome a hearsay objection with respect to some of Santos's statements. The judge. Okay, hold on. A couple of things. Number one, I don't want to prejudge. Maybe you get lucky. Maybe those she did. Sorry, again, that was my bad. Maybe those Texas officers will testify. They will. She got lucky. St. Patrick's Day. I don't know. Okay, here we are. Sorry, but I have no ability to compel them if they choose to disregard your subpoena. So I just want to let you know the limitations of the court's ability to compel an out-of-state police officer. Issue number one. But issue number two, regarding these incidences, before I know, because I know in your ex parte you made a reference to Miss Olson, and again, shame on me. I maybe should have. Oh my God! I literally thought it said twerked. No, Judge, you should not have twerked. But she didn't say that. It's tweaked. Oh my God. Okay, maybe she said I maybe should have tweaked it, not twerked it. Even better, the language to Miss Olson not being in Dallas or sort of surrounding counties. It's one thing for her to take W somewhere else in Dallas. It's another thing if you're saying, and you said that was in October, and you said that happened again in December. Or is that when you believe W was left alone with Santos's family? John's attorney. No. So in October, my client was provided an address to an Airbnb where W would be staying. And again, just so we're clear, we're dealing with overnights and not talking about, her taking W to the park. He was given the location where W would be spending the night with the respondent. She live streams everything. So they were live streaming regularly with W at this Airbnb. All of a sudden, she starts live streaming from what is very obviously a hotel room. My client asked for the information about the hotel room. I had asked. We were not given information as to where the hotel was located. That was the issue in October. It happened again that we are aware of, and we confirmed in December over Christmas. So just again, maybe 10 days ago, where my client was provided a specific location that W would be. That was in compliance with the order in Dallas and the surrounding counties. He then comes to find out, and again, this is all, the challenge with everybody posting about their lives on social media is if you're in a different location, somebody finds out about it. And so we became aware that W was actually at Santos's family's house in San Antonio. And so this is why my client called, because we didn't know, right? We had no confirmation. My understanding is that respondent was continuing to pretend that she was in Dallas, which is where she said she would be. And these two law enforcement officers actually went to the house. Respondent was not, Bree was not there. Sorry. Oh my God. Okay. They went to the house. Respondent was not there. They spoke with two individuals that were members of Santos's family. They asked if W was there. W then they showed the officer W. Oh my God. And unfortunately, because of the way W wasn't in any danger, right? And unfortunately, the way that the restraining order is issued, the officers weren't able to retrieve W and actually bring him back to my client. And they couldn't contact Brianna because she wasn't there. So all we received was confirmation as to where he was and the fact that respondent wasn't present. Wow. The judge. Okay. Again, just so we can focus the conversation, and then a last word from Miss Fonseca. And then I think you all know where I'm going with this. Again, I agree with Miss Fonseca. Maybe I'm wrong, and I don't believe the restraining order requires Miss Olson to inform Mr. Giese of specific locations prior to visitation. Am I correct?
Then Bree's attorney, just the staying part, that she had to give the address of where she was staying, knowing she's having to fly to Texas. So, you said in advance of each visitation, she needs to give him the address in Our Family Wizard, not the play-by-play of the visits as if we have a monitor. That is Dad, attached to her hip, just the address of where she's laying her head at.
The judge. Okay, then I'm wrong. Then she did. And that was required. But again, I think it goes back to respectfully this repeated allegations. I'm not going to make a finding of repeating sort of what is either pushing the line, or the allegations are either pushing the line and or failing. We had a huge one when we had the disregard of the previous court order taking the child, keeping the child in Los Angeles, and requiring 3 sheriff's deputies or 3 units to respond in a full-on standoff, basically. That was huge. That was huge. And that potentially could have ended much worse. And I'm glad that it didn't. And in light of all of that, you know, there is a concern to the extent those allegations are being made, and I'll remain open-minded. I want to hear the evidence, but if Miss Budnick proves by a preponderance of evidence that, you know, the court had an order and the court was considering lifting that order today, but the order did have an order that Santos was not to be present at the visits, and if she's able to convince the court by a preponderance of the evidence that not only was she not with W at that visit, but that W was with Santos at Santos's family's home, whether that's a danger or not, it's a violation of the court order. Preach, honey. Okay. Sorry.
Then Bree's attorney, well, I don't think that's what she said. I think she said that W was with Santos's family. I didn't hear her say that Santos was there. And that's the court I think that the court was just talking about, is Santos being prohibited from being around at the visits, which is correct. That is an order. But Santos's family, like aunts, uncles, or parents, or whoever, is not Santos. And there is not an order against that. It'd just be like if they were married living locally at W's visits. Were here, Santos would have to leave the family home if that order was still in place. These orders are not overly common, but I have dealt with them before, and that's the logistics of the reality of that sort of order. So again, Santos traveling with her, Santos staying with her when W is not there, seeing Santos's family, none of that, to our understanding of the court's orders or anything that trickles from the court's orders, none of that is prohibited. And as to the DV situation that the court is hyper focused on,
The judge. Counsel.
then Bree's attorney, oh.
The judge. Hyper focused. I don't know if you realize sometimes your word choice is interesting. Hyper focused? I'm not hyper focused. I'm required by 3044 to evaluate. So 3044 subsection A specifically references whether or not there's been domestic violence, not just between her and the child's other parent, but between her and somebody else.
Then Bree's attorney, and that's what I meant. So sorry if the word choice was not great. The allegations between her and Santos. So the date that she mentioned earlier was in June, but we were in court in August for several days of trial, and Santos was even here. So if she wanted to subpoena him to testify about that, or for a later deposition, there was certainly opportunity to do that, or to present evidence at our trial about something that she's claiming happened in June. And again, because my client is my client, and not Santos or any other third party, I still did my due diligence when the discovery requested that and ran the name search to see if my client the name search to see, is my client lying? Is there some sort of case that I don't know about in the criminal realm between her and Santos? Or even if it's not between them, did either of them get, charged with DV with other people? And there's no cases against them in LA County, either her, Santos. So again, as to DV, she's testifying about all of the evidence that she dates back a long time ago. And we had a full-blown trial since then, and none of this was presented during the trial. And the star witness that she's saying she would like to have testify or deposed, Santos, was here. And she was here. So he could have been served with the subpoena. And I did even invite a deposition when we were conferring about the discovery. I said, if you want to ask my client specific questions that aren't about the documents, because really the discovery served was about specific questions, like she admitted today, to further investigate who I might want to subpoena to come to court to testify about these things. I said, why don't you depose my client? She has nothing to hide. Ask her all the questions that you want about all the visits that have occurred since we were in trial. Depose her.
The judge. Counsel, we're back on the motion to compel. We're back on the motion to compel.
Then Bree's attorney, I'm sorry, but it's like, if it seems like I'm focused on the motion, it's not necessarily the discovery or the motion. That's a February issue when that is calendared for. It's the evidence, because she is hinging the request for a continuance on, I don't have this evidence because I'm served this discovery and I didn't respond. And I'm trying to point out the truth is in the details. If she's saying these allegations of DV occurred in June, but we were here the last week of August for multiple days of trial, then why are we getting another opportunity now to bring it forth? I do understand 3044 is an analysis of all potential DV between my client and John or her and anyone else. But again, counsel's referencing something from June, and we were in court at a multi-day trial since June.
The judge. So let me respond to that. I did read the transcripts that you all provided. I appreciate that. I will note it wasn't this court reporter, but I will say there were repellent with inaccurate quotes of the court that were a little troubling. Oh, interesting. And I have a laundry list of those that greatly change the meaning, but that's there's a line on page 84, line 23, where the court is quoted in saying, "I'm trying to undermine that." I don't even know what that means, but that's for another day. And I know you agree with it. Another line that says, "That's irrelevant to everyone," page 8926. I never said that. But separate and apart, what I didn't get from the multiple times when the court tried to redirect all of you. Sorry, I have to keep turning these off. Redirect all of you. Okay. I even said this is not a civil restraining order against Santos. So, to your point of why, when it came up, the court wouldn't allow it. It wasn't relevant at the time to what was before us. So that's in response to your question. The other regarding, I think that was, or I think what Miss Budnick was saying. There was some incident in December that are potentially relevant. There was something in June, John's attorney, and something in October, the judge, and something in October. So, we've gone round and round and round, but I'm still back to where I was. I'm still back to where I was all over again. I understand your concern about the motion to compel, and I am sure I will hear from you. I don't mean to be factitiously. I want to hear from you. And I read those discovery requests, and it would be interesting to hear from both parties regarding the motion to compel. So I get that. But again, with what we have before us, again, is a request to rebut the 3044 presumptions. We have a supplemental declaration. Frankly, I saw it at lunch when I checked the calendar yesterday. I was here late last night. The two things I saw were the deposition transcript lodged by Miss Budnick, and I read them. And then I see today, when I had a chance to check my calendar again on a break, I see the supplemental declaration and I see the transcripts. So we're both guilty of kind of doing things at the last minute. And again, that's a problem. It shouldn't happen. It happened. I understood why, but the remedy always is to give another party more time, and respectfully in a situation like this. So I appreciate your acknowledgement. And I didn't mean to focus on you, but in terms of what you previously described as hyper-focusing, again, in terms of a priority, if there's been domestic violence between her and him, regardless if there's a filing or not, I mean, you can make finding, but you can make a finding without a criminal filing. You can make a finding from a video or testimony or something like that. So they should have the opportunity to present evidence because, frankly, that is very important to this court.
Then Bree's attorney, but if she's saying that it occurred in October or June, wasn't the opportunity to lodge the evidence with the court all of those months between then and the present day?
The judge. I think she also said there's an incident in October and December, or those are about W being somewhere else. John's attorney. Those, there are so many videos online that are live streamed of the fights and allegations and references to police officers. I did file, like I said, the most recent filing that made issue of the domestic violence specifically was the October 21st, 2025 filing by my office where we attached clips of a video of a physical altercation that occurred on October 11th, 2025. The judge, well, that's October 11th, so?
The Breeze attorney, the December thing. To answer your question was them alleging that W was with Santos's family outside of Dallas County, and this is all news to me. She did not reach out to me at all about any of this information. So this is also news to me. So I can understand if she didn't lodge, if she just got the police report from out of state yesterday or whatever she said. Fine. But again, as to claiming that the DVRO was violated, that there's been DV between the new boyfriend and my client, and we're dating back to October or to June. And now she's potentially being given more months to bring her evidence to the court. What's the excuse from her perspective for not providing that evidence if it happened in October or June? We could have responded. We could have had some argument on whatever evidence was presented. She might say, "It's your client's burden on 3044." I don't know what this evidence is that they're talking about. I would have responded to it had they filed something, but they didn't file anything.
The judge, go ahead, Ms. Budnick, John's attorney. So the October 11th incident was addressed in the ex parte request for order that we filed on October 21st, 2025, served on your office, and your office responded to it. With regards to the December 25th visitation period and that violation, frankly, I didn't address it because we had a hearing, a status update hearing, and an update on what's been happening. And my intention was to update the court. The visit had already concluded by the time I was back in the office and able to do anything. It was the day of the interaction by law enforcement was Christmas Day, I believe, or the day after. And then it was thank you, Lynn. And then it was a weekend and a holiday, so there was no ability to get into the court any sooner than, frankly, today, the 6th. And it was early enough, it was early enough. And there was not another visit until the end of January. At that point, any urgency that you and I could have worked to resolve in real time had resolved. This is, my issue too is I was out. I was on vacation in Florida over the holiday. I wasn't readily available on my computer to go and file an ex parte. And frankly, the denial of our October ex parte, where we try to raise the issue of W, is not where he's supposed to be. It wasn't a life, thank you. It wasn't a life or death emergency. I understand the reason for the court's denial in terms of the existing situation. He was returned on time. Was he, can we show that he was physically damaged by the violation of the order? No. So I get it. I get why the appropriate time to bring it up is now or at the evidentiary hearing. And, to be completely candid, I think the violation had already occurred. I don't know what could have been done to remedy that after the fact. The judge. Okay, so let's refocus, just so everybody knows. I think that Ms. Fonseca is saying because she didn't bring forth this evidence previously, somehow rather she waives her right to do it. I respectfully disagree with that. Amen. And just so you all know, I don't analyze the 304 piece of mill. I don't know. I don't take paragraph A and separately look at paragraph B. I look at the whole thing, and it's a whole picture. Did she successfully overcome the presumption? Did she meaningfully attend the class? Oh, not this again. Did she attend it in a way where she sort of learned anything from it? Has there been additional domestic violence? And it says within 5 years. Anyways, so I mean, the code itself says you can go back 5 years. Did she comply with the court orders? You know, it's a general thing. It's a whole sort of totality of the circumstances. I'm not taking it piecemeal. I'm not going to analyze one thing today and another thing tomorrow. I'm going to do it at once. I'm going to do it at once and for all. And again, you know, we can say this for, and you're a very good advocate, and we have that evidence before us, and I'm going to, you argue? Wait.
That
Sorry.
makes no sense.
Let me say that again. And you're a very good advocate. And when we have that evidence before us, I'm going to I'm going to let you argue. Sorry. I bet that's what it's supposed to, I'm going to let you argue. Okay. But I just want to let you know, I'm not sure I necessarily agree with your position that it was a Santos's family. It's not Santos. Because that's one of the issues violating the letter of the law versus the spirit of the law. The idea behind that is that Mr. Giese, and I know you're trying to rebuke that too, and I'm happy to hear that on the next court date too, but it was filed supplementally. It was filed this morning. So Ms. Budnick is also at a disadvantage regarding these efforts to discredit Mr. Giese. I want to hear it all at once in one hearing. But back to my point. I mean, there was testimony that he doesn't feel comfortable with Santos around his child and the reasons for all of that. So to think that, well, it's sort of a technicality and the child is not with Santos, but he's with Santos's family, but she's not there, I think that's more of a violation. I think that's more of violating the spirit of the law versus a letter of the law. I'm not going to have a full argument today. I'm happy to hear more once I have the evidence, but I don't think it's a cut and dried as you think it is. So I don't want to hear all of that. And I appreciate everybody's input. But the bottom line is, I don't think we're ready today. There's more I want to hear. I definitely want to hear if there's been domestic violence. I definitely want to hear if the spirit of the letters of the prohibition. I mean, because I was today, I'll be frankly with everybody, I was ready to seriously consider lifting that. I understand he's the father of the child. I absolutely understand that. But you know, if there's evidence that she's continued to violate it, I mean, then say, okay, well, you know, you did your class, and even though you violated, the time has come that she's about to have a child. I should lift it. I think that sort of encourages her to continue to not comply with the court orders if I made that finding. So I don't think I can do that. I can do this in a peaceable manner. I know that's a disadvantage to her. I'm not really sure why, without going into detail, for what purpose you want to show me her medical records in chambers.
And Bree's attorney, because none of this is public information, and her and Santos intend to keep it that way. I can't understand. Whoa, okay, making up words. Let me retry that. I can't answer your question any further without.
The judge, I got you. I think I'm reading between the lines here. Okay, I mean, really. And back to the court's original point. Look, if I find by preponderance of evidence that there was domestic violence between her and the new child's father, I think we're kind of a game over.
Oh,
In terms of in terms of overcoming the presumption right now. So that's a big one. I think we need to sort of get to the heart of that. She said, game over, bitch. Game over. You're out of here. 3 strikes and you're out. Sorry, she didn't say all that. I did. That my bad. I apologize. She did say game over. I just added in the rest. Okay, I apologize. Miss Fonseca, go ahead, miss.
and then Bree's attorney.
Game over.
And it wasn't saying, just to correct the record a little bit, that I think that they should be precluded from bringing evidence forth about the, oh my, they should be precluded from bringing evidence forth about DV because, like you said, the code is clear. 5 years up until now is the time frame that we're looking at. I was just saying, unless it happened yesterday, there's been ample opportunity based on the dates that council shared to share that evidence so we can respond to it or so the court can review it for the purposes of the 3044 analysis. And I'll say it again. I feel like it was a strategic and purposeful move to not do it before today so they could request a continuance, knowing that the continuance would likely mean that the orders remain the same. When everybody knows that we came to court today hoping that the court would at least consider the visitations to be moved to California, and it seems like it was strategically set up this way to get a continuance to keep the orders the same way, which means she keeps having to travel to Texas, paying double rent essentially, all the airfare costs, doing this while she's pregnant, etc. And to the Paris thing, she did her gender reveal with W in Paris. She has now done gender reveal with the new baby in Paris. So that was where the Paris thing came from. And Santos also asked her to marry him. So now they're engaged.
The judge says congratulations, but really quick, somebody asked me to reread the part where the judge said game over. So I don't know if it was for screen recording purposes. So if you guys wanted to screen record that part, here it is. This is per request. Okay. All right. The judge says, I got you. I think I'm reading between the lines here. Okay. I mean, really. And back to the court's original point. Look, if I find a preponderance of evidence that there are domestic violence between her and the new child's father, I think we're kind of game over in terms of overcoming the presumption right now. So that's a big one. I think we need to sort of get to the heart of that. Okay, so I read that for you guys. I'm going to go down to they're engaged. What do you fucking do? The judge says congratulations. Okay.
Then Bree's attorney from that trip. So yes, they did go to Paris for the gender reveal. It was a quick trip and she's obviously back. She's obviously now back. But it's not just the travel, it's the other things that we also shared in the supplemental pleading, like supporters of John's. Again, whether or not he's involved, they're saying he's asking them to reach out. There are random strangers, so we can't know that for certain. But these people going to the lengths of finding out who it is, and then contacting the host of the Airbnb rental. They have mass reported her assistant's account on Airbnb.
Her what account?
Her assistant that does her bookings to keep it private as to who is making these bookings. Her assistant's account and the assistant's name and picture have now been broadcast all over TikTok with encouragement from John's supporters to mass report the assistant's account so that she is now precluded from making reservations on the Airbnb platform. There have been people posing as DoorDash and other delivery drivers loitering outside of the premises where my client is staying in Texas. So, it's not just a travel situation because she's pregnant. It's not just a money situation because she's paying rent here and then having to pay for an Airbnb, round trip flights, all of W's essentials that have to be brought each time she goes there. It's accumulation of all of those things. And she did sign a lease on a 4-bedroom house in the valley, which is very child appropriate for exercising visitations here. She's paying on the lease to live there. So, of course, you would hope for all of those reasons that the court would at least give her a shot of doing the visitations here in California. Maybe a middle ground would be we give them their continuance and let her at least try in January. We suggested that they split the airfare, but she could even, at least this once, do it all herself. She'll fly to Texas. John can meet her at the airport. She can pick W up. She'll fly him back at the end of the visit. She'll take him back to Texas. If that's something the court is willing to consider, we would ask for the visit to be 2 weeks instead of 1, so she actually gets some time outside of the airport and airplane to hang out with him here in California. But maybe that's a middle road suggestion that we could make to the court if the court is inclined to grant the continuance that counsel has requested.
The judge. Okay, let's take a break and then we'll come back at 3:05. So with that really fast, we're also going to take a break, but I have to say something because I find this funny. Bree is stating she has no income. She is making no income. So I wonder if the judge is then going to ask, probably not, but maybe the forensic analyst, if you have no income, what do you need an assistant for? If you're not doing anything to make any money, what would you need an assistant for? Like, I have a job. I don't need an assistant. Shit, I do 2 jobs. I don't need an assistant. So I'm extremely confused on that. Okay, I'm gonna take a quick break, use the restroom. How about you guys take a break, use the restroom? We'll take 1 to 2 minutes. We'll come right back, refill your drinks, get you a snack, and come on back because we are on page. What page are we on? We're on page going on to page 59. So we're halfway through. I'll be right back.
We're about to go on page 59. The other thing that just popped in my head is that you can't fly to Texas for your visitation, but this one time you can fly to Texas, pick him up, fly back to California, keep him, fly back to Texas to drop him off, fly back to California to be home. Thanks, guys. I usually don't mess up this bad, but apparently I don't know how to read today, so I'm sorry for my mistakes. This was January 6th. Yeah, I don't know if the judge picks up on it or not, but I am curious because that's a lot of flights, but yet you can't just fly twice and stay in Texas.
Okay, I'm back.
I don't know if you heard me, Angie, but it popped in my head where I was like, you're high risk, but you're willing to fly to Texas to fly back, then to turn around and fly back to Texas to fly back. But you can't just fly there and have your visitation there.
Right. Well, and the other thing too, that I was saying when she first came out with that, well, when this all came out, right? Because now in this thing right here, you guys, that we just read, they just made the proposal before they went to break that she'll do the traveling this time to bring the fly there, to fly back, to fly him there, take him home, fly back. So taking 4 trips. But then she wants John to bring him here, fly home, and then she'll take him home. But the problem with that is she doesn't take him home on time. That's usually the issue, right? Is her not getting him back on time. Or her, or a concern of if she will return him or not. That's a concern. So I don't know why they would go with her returning. But then we already know this, so I'm not ruining anything. But at the end, when she finds out she doesn't get what she wants, she then says, well, I'm high risk, I can't travel. But why did she just say in this same day that she's going to tell the judge she can't travel? Why did she just offer to travel? So, crazy. Thank you so much. Okay, I'm going to get back to reading because we still got a ways to go. Might be a long night. But for those of you guys who cannot stay up, I will stay up and I will make sure that this gets on my YT tonight, just so you guys know, okay? Just don't forget to do your daily heart meeting. That's all I ask. We're at 1.1K. Thank you guys so much. And you guys are almost 400K taps. I so appreciate you guys. Okay, love you. We're almost at page 60. We're over halfway through. Okay, and I won't stop. Okay, Judge.
Hi,
back on.
Sorry.
Oh, that's good. The judge, back on the record in the Giese versus Olson matter. All right, let me just ask general questions. Is there, Michael, may we have some dates for an evidentiary hearing? Can the parties do March 2nd or March 3rd at 1:30 in the afternoon?
Embree's attorney, checking. I already have a trial.
Ms. Budnick, go ahead. If you are unavailable, then that resolves that issue.
Embree's attorney, yeah, the 3rd I have a trial in Orange County.
The judge, what are you going to say, Ms. Budnick? John's attorney. I was just thinking my motion to compel hearing is set for the 9th, and assuming that it's granted and we have 30 days to get responses because we didn't get any, that would put us at, I think, March 9th, that I'd get the responses back, and I would prepare to have those before even starting the hearing. So if we could do mid-March or late March, that would be preferable to me.
Embree's attorney, and my response would be, I don't think they will be granted once the court hears everything at the hearing. So I would be against pushing out this continuance even further.
I'm sorry. I'm not so you know who her attorney reminds me of? India. Remember how India thought that lawyer, like that was his name, was lawyer, like that he wasn't really a lawyer. His mom just named him lawyer investor, I guess. How is she going to tell the judge what the judge is going to do? What is it? India. Oh, I don't know. Well, whatever. Okay, listen. It's India now. Her name is India. We've renamed her officially. Stop getting over here. She's India. Anyways, I'll continue. Well, just so everybody knows, and just so you know, Ms. Budnick, I'm seriously considering in the interim, just to Ms. Fonseca's concern about visitation in California, regardless of whether she went to Paris or not. If the baby is due in summer, at some point, it's going to be harder to potentially, John's attorney, I would like to address that. And perhaps I could address that before we deal with the dates. The judge, okay. Ms. Budnick, the issue with visits in California. Number one, had we proceeded with the hearing today and orders being made, my request would have been, and my request will be at the hearing when it's set, is that Ms. Olson's visits be monitored again. Given the extent of the violations of the order, the line to my client as to what actually is going on at visits, the concerns about domestic violence with Santos, and so I think that there is a heightened risk if she is now going to be exercising visits in Los Angeles, where my client does not reside. The reason for the order limiting Miss Olson's visits to Dallas and surrounding counties is because W lives in Dallas. My client lives in Dallas. He's in at least a drivable distance away if something were to happen. I think sending W to LA for visits to a residence that Miss Olson shares with Santos is going to be impossible for anybody to monitor and enforce the court orders as to whether or not Santos is present for visits. I think it will also be impossible to really assess where W is, because once respondent is in Los Angeles with W, she can travel anywhere she wants. Amen. And my client is going to be limited in his ability to act and intervene. And I anticipated, or I would assume, after hearing what we've now relayed to the court, she's probably going to be more careful about what she live streams during her visits. So there's a risk. The judge, hold on. You know we haven't talked about substance of the allegation, but I'm going to ask Santos to go outside because we're going to discuss things. So if he could leave the courtroom, get your ass out of here. Just kidding.
He gets kicked out every court hearing, too.
Literally. Hold on. Okay, then it's Miss Budnick. So, John's attorney, thank you. I wasn't aware he was even here, or I would have asked. The judge, hold on. Oh, to exclude him? Miss Budnick, yes. The judge, okay. Miss Budnick, anyways. The judge, wait. I'm not done. Hold on. Sorry. I wanted to stop you because once you guys get started, you go on for a while. So I just want to, I don't mean that rudely, I just want to, Miss Budnick, John's attorney, sorry, I'm long-winded. The judge, no, I didn't say either one. You both are great advocates. There's a lot there, so I want to make sure I don't miss anything. I want to follow up on certain things, all right? Again, I'm not being dismissive or anything, but the general allegations and the videos are that Miss Olson is seen pushing Santos. John's attorney, in the video, it appears that the domestic violence is mutual. To be totally candid, it sounds like there is a domestic violence on both sides. The judge, and mutual pushing? Is there anything more? Not that pushing isn't. John's attorney, verbal abuse as well. The court, what's the verbal abuse? Miss Budnick, yelling, screaming. There's been other videos I've seen where law enforcement comes to the door. I don't necessarily know the actual altercation. Wasn't live streamed. But the police officer's interaction was live streamed. The issue in Cantalina. Really all. I don't want to say all. I don't want to misspeak, but many of the interactions that I have become aware of, my client has become aware of, seem to involve alcohol and drinking. I know Miss Olson is pregnant, so I don't necessarily have a concern that she is using substances. But I think that raises some issues that Santos may be. And that could be, I don't know if it's a catalyst for the domestic, I don't know. I'm speculating. But there seems to be like mutual DV. It does seem that the pushing and physical violence is on Miss Olson's part. The judge. And are the altercations that lead to Miss Fonseca's point, are they since June or are they before June? John's attorney. So there are altercations since June. I know I keep referencing this, but maybe I'm not making it clear. The ex parte that we filed included the video that was live streamed. The fight occurred on October 11th, 2025, and Miss Olson is repeatedly pushing Santos Santos in that recording. It appears to me that they were both intoxicated, but she would have been pregnant at that time. So perhaps she wasn't. So, again, I'm speculating as to the reasons. I'm not involved in their life, but I did see the video recording, and it was a live recording and a live altercation on October 11th, 2025. The judge, okay, hold on. I know we're not, look, I'm just going to be frank. I'm trying to balance all the various interests here. I really, really am. It is not my business to get into Miss Olson's personal, it is a little bit, but it's not. And congratulations on being engaged and all of that. She literally says, and congratulations on being engaged and all of that. Anyways, I'm trying to balance the fact that he's the father of her new child. And though the Williams case does not apply because they're not 100% blood siblings. There is a presumption if they were that, it's not good to separate siblings. They are half siblings, and I have yet to find case law on sort of where that line is. But at the end of the day, going forward, presumably they're engaged. Santos is going to continue to be in her life. And at some point, hopefully, she's going to continue to get more visitation with W. And so it's the anticipation. And I think that maybe it's not the inevitable, but at some point, Santos will be not just in her life, but in W's life. Maybe. But one of the things the court has to always evaluate in any custody and visitation is who a parent is surrounding themselves with. Oh, shit. And look, you both engage in some really concerning behavior online. I mean, there was references to rage bait. Both rage bait each other. You both say horrible, horrible things about each other. Horrible. And I don't know the extent of the damage that's going to be done one day when your children go online and can access the horrible things that you've said about, despite what the court keeps saying. I also recognize, as I have said, this is not a defamation case. And you both make a substantial living, I guess, engaging in this kind of behavior. So as much as I'd like to say stop, I'm really not sure I can enforce that. But I do draw the line at physical behavior and screaming, because that endangers a child. And there is case law. And there is even a code. It's Penal Code Section 273AA. It also says that exposing children to domestic violence can be criminal, potentially. I'm not saying it's just the court and the law recognizing the danger. The emotional harm to children from being in those situations. And so W is before me, and the court has concern. And especially if she's pregnant, and there's pushing, and there's domestic violence, there continues to be, frankly, she seems like a very smart young, Your Honor, all due respect. Anyway, sorry. Okay, there continues to be, frankly, she seems like a very smart young lady. But it seems like there's also evidence she makes some really not wise choices in some respect. They both do. But it goes back to, I'm trying to balance, the issues about allowing her to have her child's father in the life of W's, or in her life and W's life. With the fact that there is evidence of domestic violence, then I think, the presumption is just one concern to worry about. So frankly, I don't know. I mean, have you seen the videos they're referencing to?
The Embree's attorney, she hasn't served the video. I saw the clips in the ex parte that she's referenced, but I haven't personally saw the video.
Miss Budnick, this is Judge Miss Budnick. You haven't sent her the video? John's attorney. It was an ex parte filing, and I referenced the screenshots. And then the ex parte was denied. It was set for a hearing, so I'm happy to provide the video. The judge, I'm surprised it hasn't been provided previously, because literally the court would ask to see it. Miss Budnick, I'm John's attorney, sorry. I mean, I would have had it ready to go for a hearing, but in addition to the point, the judge, wait, let's not move. Miss Budnick, as long as I can finish. The court, let's not move. John's attorney, thank you. The judge, I just, I recognize the delay. I do. The court really wants to see the video. If there's an authentication issue because one of the things, I'll be frank, I was going to consider having some visits in California. I at least maybe was considering lifting the prohibition on Santos. I'll tell you right now, absolutely not. If I was a judge, abso-fucking-lutely not. But I'm not, so it just says absolutely not. Pending hearing, more information. But then the question is, her favorite word, frankly, how do I control if she's allowed to have visitations in California, then there's another one concerned about her traveling. But on the other hand, I hear she's going to Paris. So I'm trying to sort of balance both things. I mean, I have a concern because I think the envelope was being pushed in terms of saying Santos can't be there. And then I hear, well, potentially that W was at Santos's family house. So I mean, it seems like there's again the pushing the court's envelope. And so, the concern is to allow her to have a 2-week visitation to have visitation to say Santos can't be around. But based on what I've heard, I don't have a lot of guarantees that that's not going to occur again.
Then Bree's attorney, I could give you structure to hopefully make you feel like that would be guaranteed. At least the lease that was signed is on a 4-bedroom home. These two in the audience are parents of 8. They live within a 5-minute distance of this home with their children. They're both stay-at-home, work-from-home parents. So Santos, during the time that my client has W at the residence, Santos can easily stay with him. They're all friends. And then my client's mother, who currently lives in Texas, is going to be moving into the house with them to help with childcare and the new baby when the baby comes this summer. But she's moving in next week. She's a
This was 2 months ago, y'all. This was 2 months. I'm sorry. This was 2 months ago. That bitch still ain't moved in. My part. Okay, my bad. Sorry.
she had Brianna earlier in life, so she's still a younger lady, not at retirement age, but she's taking this time away from work, similar to how John's mom is helping him with W, to come stay with her and Santos and help take care of the new baby. So mom was previously allowed, if the court recalls, her dad and Miss Budnick to be at one of the visitation facility visits. It was the Mother's Day one specifically. There was no issues. Maybe if the court would consider mom signing one of those, I forget the form number, but those non-professional monitor forms where you consent that you're going to do all of these things and act as a monitor. I think that requesting professional monitor visits to be reinstated at this time would be grossly inappropriate, especially when there's been nothing filed to confirm anything that Miss Budnick is saying today whatsoever.
The judge. Oh, I agree with you. I mean, I think the fact that she has not sent you the video, thank you, love, is troubling.
Then Bree's attorney, right. And then San Antonio thing. I understand. I too was away in the Midwest for Christmas time for a week, but I'm always connected to my emails. That's just kind of the name of the game as a lawyer. So I understand she was out of town and she said she didn't do an ex parte because of that. But the fact that this court hearing is the first time I'm hearing of any of this from Miss Budnick is also concerning.
The judge. Well, not as to the DV. She says it's in the October filing.
Bree's attorney, no, the San Antonio thing about W around Christmas time is what I was referencing.
The judge got you. Mind you, you guys, this court is 10 days after the San Antonio thing. So I don't know how quick they could have got it. But anyways, I was going to say that. Got you.
And Bree's attorney, so this is the first that I've heard from Miss Budnick about this topic at all. So I don't like to use inflammatory language in the courtroom on purpose, but this does feel like sandbagging.
I understand.
Then Bree's attorney, because this has been calendar for a long time, and all this stuff didn't just happen yesterday, so I would expect we usually have a good relationship when it comes to meeting and conferring before filing stuff, at least since I've been around.
John's attorney, can I please respond? The judge, no, but okay. But what we're not going to do is bring Miss John's attorney, just briefly, the court. No, Miss Budnick. I'm sorry, I have to raise my voice, but I keep saying no and you keep talking over me. Okay, so respectfully, I give each one of you an opportunity to respond. I do every time. What you're not going to do is interrupt the court. You're just not. You're not. Okay? Let her finish and you will respond. You are online. It makes it more difficult and there are some delays. And we have a court reporter, and I'd like the transcript. She's a fabulous court reporter. I'd like the transcript to be accurate. And maybe part of the reason why we've had some inaccuracies in the past is because we've had this. We talk over each other. The court has to ask you to stop. You interrupting each other. We are not going to do that. Miss Budnick, let her finish, and I absolutely will give you the opportunity to respond. Go ahead, Miss Fonseca.
Then Bree's attorney, I really don't have anything else to say unless you want to see the lease, or I have the listing pulled up so you can see the pictures of the home personally. But again, I won't say the address on record for obvious reasons.
The judge, I will not ask you to do that. That's not my concern. That was not my concern. My concern, I'm going to look straight at your client. I feel like you've pushed the court's envelope. You are a very smart young lady. You are. And I get concerned, and look, you dodged a bullet, for lack of a better term, with that whole thing that happened with the sheriff's department. Talking about the kidnapping. It was a court order that ordered you to return the child, and you did not. It required 3 sheriff deputies to come and have a full-on standoff. And I was very clear about my order with Santos. And yet, I hear you, or W is at Santos's parents' house. So, there's only so many times the court's going to keep hearing that. And then the court is not going to cut you the slack that I think you are going to continue to cut you. So I'm a little concerned about that. That's not my concern about where she's living. And I recognize your privacy gets invaded and it's sad, but they both chose to live in the public. And I'm not being dismissive of it. I would hate the fact, that people show up. But you've both opted to make this your life and to expose your child publicly. That's your decision. But this is what happens. So I'm trying to do the best I can. I don't have any concern about the house and where it is. And I know you will provide Miss Budnick with the address so it doesn't get out publicly. But that's not my concern. My concern is doing what she's doing again, which is sneaking Santos back in, especially in the light of the fact that there are allegations of domestic violence. And frankly, Miss Budnick, you would be in a much better position with this court if you would have sent that information to Miss Fonseca previously. Because then the court would say, show me the video. And I think right now, she has an opportunity to object. Because she's going to say, it's not fair for you to show me the video that I've never seen. John's attorney. So I think I gave her the reference to the video. It's a video of her client. There's screen grabs of the video. I think you can see what the video is. We have never asked to send her a video. And I did just want to comment with respect to the December visit, because I don't want this to be a reflection of my client about coming forward with something. And I don't think the lack of communication to Ms. Fonseca negates what occurred. But just so the court is aware, I transitioned between law firms over December. So the entire month of December, I was in transition. I was traveling. I, frankly, was not able to get the file transferred over. It was not and frankly, I didn't have the time to meet in constant correspondence to Ms. Fonseca on issues. And so I would like to apologize to the court. I would like the court to know this isn't my client not making issue of things that happened in December. He brought them to my attention, given my schedule. I thought that it was appropriate to bring it up at court today. The judge. Let's do this. Send it to her right now. Send it to her. Just send it to her. Yes, send it. Sorry, I got excited. Send it to her. Oh, send it to her. Send it to her, bitch. Sorry. John's attorney. Okay, and again, I'm the judge. Send it to her, and we'll take a break. Oh, send it, bitch. Send. Red Rover, send the video right over. I get so excited. Oh, my God. Okay, we're taking a quick break. Okay, anyways. We'll take a quick break. Miss Budnick. Can I please respond, Your Honor? Why would you respond, lady? Just send it over. Anyways,
Yeah.
Can I please respond, Your Honor? The judge. Well, here's the thing, Miss. John's attorney. It's important. I'm in the process. I just transitioned to a new firm. The video was sent. Oh my God. The video was sent to me at my prior firm. I prepared the pleadings at my prior firm. I need to review the file that I received from my prior firm, make sure it is there, and send it. So unless my client can pull it up very easily and send it to me, it may take a minute to get it together. John, do you have the ability to send that video to me now? Mr. Gacy, well, there are multiple videos. Miss Budnick, if we could take a break, the court, yeah, the reason why the sooner you send it, the sooner we could look at it, the sooner we can. I didn't mean to keep interrupting, but I was like, let's send the video. Let's give her the opportunity. John's attorney, I do. Just before we take the break, the other thing I wanted to add is my client has concerns with W spending 2 weeks with respondent. He has observed W's behavior before and after visits. And I think it's important to hear from him with regards to how W acts before he goes to visits with his mom, and then when how he acts upon returning from visits. He has concerns about W's welfare and having to spend extended periods of time with her. The court, okay, hold on. The video is one thing. So before we keep talking, I need Mr. Gacy to start getting ready to send the video so you can look for that. But you need to get off of the phone in order to do that, sir. Mr. Gacy. Well, I need to get off of, to get out of this office and grab my stuff. The court, the judge, okay. John's attorney. Miss Budnick and wait, what? Oh, no, that's still the court. Oh, sorry. It looked like it was her. The court, okay. Miss Budnick. Miss Budnick, in fairness to Miss Fonseca, that's not something you just bring up at a hearing at 325. You put that in a declaration that can be constructed as, Miss Budnick, I'm not going to, Miss Budnick, if you interrupt me again, I'm going to cancel this hearing. Woman, if you don't shut up. No, I love you. Shut up. I'm going to cancel this hearing. I don't know how many times I've told both of you there's a way to comport yourself. I think it's conduct yourself. But they say a way to comport yourself in court. And apparently what I say just doesn't matter. It does matter. Stop interrupting me. I don't think I need to be any clearer. I understand you are a very vigorous advocate, and I admire that. But I have a terrible record from before, and I think part of it is because these hearings are like this. You talk over me, and you talk over each other. It's not going to happen anymore. Do you understand me? John's attorney, I do, and I apologize. The court, I don't need an apology. I just need an acknowledgement that you're not going to do it anymore. I'm not offended. Don't do it anymore. So here's what we're going to do. That is not something I'm going to address at 325 on a hearing, Ms. Budnick. That is not something I'm going to address at 325 at a hearing. That was not part of a supplemental declaration. This was in anticipation. So this is what we're going to do. I will tell Ms. Fonseca, if that video has some concern, it doesn't matter how long this hearing is. Maybe we'll try and delay it as little as possible, but it would seriously have this court reconsider any visitation in California. So I think it's important, rather than getting caught in the weeds, that we send the video to Ms. Fonseca. Give her an opportunity to review it, and let's call this back maybe at 10 to 4. I understand this is all. I want to give everyone an opportunity to look at it. I'm not going to hear any more argument about this. Ms. Budnick, have your client send it to her. John's attorney, I will. The court, okay. Let's do that. We're going to John's attorney. Jesus Christ, and she interrupts again. I just want the court to be aware. We did bring up W's behavior before. Taylor, love you, girl, but why? Anyways, we did bring up W's behavior before visits in October declaration that was filed. That was responded to. The court, okay, thank you, all right. Let's send it to her. Let's recall this. Let's maybe, I don't know, how long is it going to take them? Let's recall this at 10 to 4. Okay. Break taken. Okay. Are we ready, guys? Let me take a quick drink. We're almost done. Won't be too much longer. Jess, I'm reading the transcript from January 7th. Now the break is back. The video has been sent. All right, here we go. I'm the judge again. Back on record in the Giese versus Olson matter. I did go back and look at the ex parte again. And to Ms. Budnick's point, she did provide the screenshots back in October. So if she wanted an opportunity for Ms. Fonseca to review it previously, has it now been sent to you, Ms. Fonseca?
Then Bree's attorney, yes, and this is my laptop that you're seeing, and this is a clip that she sent me.
The judge, okay.
And Bree's attorney, and to the court's point just now, I did go independently on TikTok on the break, and there's several different, I guess, versions of this clip. So I would have, yes, wanted to see which clip they were referencing specifically in the paperwork.
The judge, okay. So why don't you go ahead and lay whatever foundation you're going to lay for it, Ms. Budnick? Oh, wait, what? Oh, by Ms. Budnick. Okay. So this is John's attorney talking to John. Actually, why don't you be Ms. Budnick right now, and I'll be John.
Sounds good.
Okay.
John's attorney. John, do you recognize the clip of this video?
John. Yeah. So at this point, you guys, she's John's attorney. I'm just Don, so we don't have to keep saying that. Yes, ma'am.
What is the video depicting?
The video is the court. This is the judge. Oh, nope.
Then Bree's attorney, objection, lacks personal knowledge.
The court, hold on. I'm sorry. Santos is not allowed to be in here. You are, sir, I apologize. Go ahead.
Then Bree's attorney, I would say objection, lacks personal knowledge. John wasn't there, so I don't know how he can lay foundation about that part of it.
The judge, yes. So I asked the question wrong. Let me just ask you, Mr. Giese, when did you see this video? John, I believe I saw this in November or December-ish. The judge, okay. John, maybe October? The judge, all right. So why don't we do this? John, I think this is at a Halloween party. So this is October, I believe. The judge, and you're saying you know this because the video depicts that it's at a Halloween party. John, yeah. John's attorney. Oh, yeah, go, sorry.
John's attorney, perhaps refresh his recollection by looking at when the video was received. I don't know. I feel like he's guessing.
The judge, yeah, I don't want to do any of that. I love her.
Then Bree's attorney, I'll just tell the court. It was early October. It was not Halloween. It was the 11th or the 12th, and that's the time stamped. Or you can see that on the video. And if you look at the clips online, that's when they were all posted.
The judge. Okay. Well, that's really all I need because I think that anyone can lay foundation of the video of the video. If they recognize the people on here, the date isn't a dispute. So maybe don't we just go ahead and play it and the court will hear any objection after I unring the bell? Go ahead. Whereupon a video is played in court. The judge, was there another clip?
Then Bree's attorney, not that we received. Then John's attorney, not that was referenced in our motion.
The judge, okay. So let me just, for the record, because we have a court reporter, the court can recant what it saw. I saw a video, what clearly was Miss Olson. I saw a video of what appeared to be Mr. I'll just call him Santos because he's in the court today. He's been in the court previously. There was a party. There was a lot of people. I can't tell whether she was drunk or not, or under the influence. There was reference to she's drunk. She's not drunk. I don't think there's enough for the court to make any determination. She goes and grabs his shirt and appears to push him. There's a lot of, language. And then she sort of storms away, okay? Are you going to have more at the evidentiary hearing, Miss Budnick?
Then John's attorney, I will have more at the evidentiary hearing. Then Bree's attorney, and just to refresh the court's recollection on John's testimony in the ex parte, he said, quote, respondent hits and pushes Santos multiple times in a row. And I believe that was loosely the description that Miss Budnick gave of the exact clip before we watched it. And I mean, seeing what I just saw with my own eyeballs, I don't think that that's accurate testimony about what we just watched.
The judge. He also says on the clip, and again, my sense is we'll hear from him. That's why I asked him to leave the courtroom. He also said, she struck me like 5 times before off camera. Miss Olson. She said on actually, or he said on actually. Wait, what? So, okay, the judge says, the judge is saying that Santos said, she struck me like 5 times before off camera. Then Bree interjects herself, which is dumb when you have an attorney, and says, he said on, actually. The court, oh, on camera? Okay.
Then Bree's attorney, if the court wants to ask her questions, of course, after swearing her in, I'm totally fine with that. She can answer anything that you want to ask her about that evening.
The judge, sure.
Then Bree's attorney, but I don't think either were sworn in if I'm...
The judge, hold on.
Then
John's attorney, that's okay. John's attorney, I can no longer see anyone. The court, let's do that then. Okay, Mr. Gacy and Miss Olson, please raise your right hand. The clerk, please raise your right hand. Yeah, parties. Okay, the clerk, you're each solely. Okay, they both said, and they said I do. I don't need to read all that. The judge, all right. You want to tell me what happened in that video that led you to sort of grabbing his shirt and striking him? Miss Bree says, yes, ma'am. There was a friend of ours. He had a birthday party in an adult setting. Yes, there were drinks. I had just suffered a miscarriage previously to that. So emotions were very high for me. I still had people, close friends of ours and people online, even current to that video, asking me personal things about my pregnancy. So I was very emotional. I did have a drink or two, and I was told, I didn't find out until after, but Jack, who it was his birthday, and Santos decided to play a prank on me on camera while they were streaming. I was not aware of this prank, obviously. The prank was to hide my phone and say that They lost my phone of some sort and just kind of get my reaction. Stop it. I found this out after the video was done. And yeah, so they just kind of wanted to get my reaction. I wasn't feeling too great because of my miscarriage and the drinking and then the environment. So yes, I was very upset thinking that my personal phone could have gotten lost by my partner. So yeah, we were kind of like bickering, I guess, and I was raising my voice, which I probably should not do to my partner, which I do regret. Oh my God, listen, I'm reading it just like this, you guys. There's no pauses. There's no, I had to take a breath, sorry. And that was kind of the whole thing about the video. I didn't know it was a prank until after. That's a clip, but off camera, obviously, I'm telling people, like, when I say the part, dumb bitch, get on your knees, and then we start chanting, on your knees, on your knees. I had kind of, at that point, someone had kind of like told me, like, I think they're pranking you. And so at that point, oh my God, I already knew. And the rest of it was just for clips, just for like rage bait. Like, I knew it would go viral. It did go viral when I had told him to get on his knees. I don't believe I struck him in any way. I did. And the judge says, push him. Bree, push his shoulders. Yes. When I was saying that to him, and then I just kind of walked off, the judge, all right. Well, it came out, and I don't know if that's what Ms. Fonseca was going to tell me. There's nobody else in the courtroom that I've noticed that.
Bree's attorney. Well, yeah. So it was in mid-September, and I have the medical records of that. So this pregnancy is a new one, and she is due in July, and I can give you the records to give you the specifics of that. But the fact that she miscarried the first one and just found out about that after reporting for bleeding in September, then had it later confirmed by an ultrasound by her.
Oh, you're cutting out again.
Oh,
there you go. You're back.
Okay.
That's okay. You can just continue. No, you're okay. Just go start it where the then had it later confirmed.
Okay. Then had it later confirmed by an ultrasound by her OBGYN that is in fact what occurred, a spontaneous miscarriage. That was not, and it was not until this moment or whenever this transcript gets out, public information.
The court, and I don't want to go into much detail.
Then Bree's attorney, no, I'm not going to go into detail, but when we said that, like mentioned in the pleading, that she's been getting death threats and a lot of hate online, it's specifically because her and Santos did not face the general public and say this is what happened. So there's been a lot of speculation. Did she AB on purpose? Like, has she lied about being pregnant this whole time? I think she meant to say how she lied about being pregnant this whole time. The answers to all of those questions are no.
The judge, wait, hold on. No disrespect. It's not important to me. Hold on. I don't mean to be dismissive, and I'm sorry for your loss. I guess this is what I was trying to dance around it. So she's newly pregnant?
Then Bree's attorney, yes, and due this summer. And I can give you the specifics, but I won't say the specifics on record.
The judge, that's fine. But that kind of changes everything. Because I spent a lot of time saying I'm sort of frustrated about her traveling. Well, turns out it sounds like she was okay to travel because she was either not pregnant or early in a new pregnancy. So I appreciate that came out. It probably, Bree, interrupting. I got pregnant shortly, like very, very shortly after the miscarriage, by the way. The judge, okay? All right. Bree. So it wasn't like a long period of time that I wasn't pregnant. The judge, that's fine, but this is what I want you to understand. Much of what the court crafted, and the reason why I said today's date is I anticipated she would be at a point in her earlier pregnancy that would make traveling hard. But you're not at that point yet. Congratulations, you're newly pregnant. It sounds like you're still potentially in the first trimester. Bree, I'm in the second. The judge, second, okay. Well, look, I'm trying to balance. Again, I'm not a doctor. I don't know what the doctor's saying, but I mean, she was okay to travel in December to Paris. She's presumably going to be okay to travel to Texas now, at least between now and the next court hearing. If she still had the earlier pregnancy, my sense is she would be in her third trimester at this point where you can't travel anymore. So I appreciate the information. I'm trying to be sensitive about it, but there's a lot here. Look, I appreciate you telling me that. It changes the video. That video would have been much more disturbing if you were pregnant at the time. I understand emotions and I understand all that, but that's not how a pregnant person should act. If you're striking someone and you're potentially getting into physical altercations, then good for him for withholding from not doing anything. I give him kudos for that. And I understand your position, but it's part of this larger issue that the visitation and the travel and all of that. Because, I don't know if we even picked a date, but I think it kind of affects when did
Then Bree's attorney, I think you said April 2nd.
The judge, can everybody do April 2nd? John's attorney, yes, I can do April 2nd. The judge, all right.
Then Bree's attorney, yes. And just as a reminder, it's not just the pregnancy-related travel. It's the additional stuff that we shared earlier about the masses trying to make it impossible for her to have a safe visit or even a bookable visit on Airbnb, which is what she uses over a hotel because it's cheaper to do an Airbnb versus a hotel. We have all of this that keeps happening since the visits from supervised to not supervised.
The judge, I get that. Had she not played Footloose and Fancy Free with I'm sorry. Oh my God. Sorry. The judge. I really should read these before I come on with you guys, because sometimes the shit they say just cracks me up. Okay, hold on. The judge, I get that. Had she not played Footloose and Fancy Free with Santos being at the visits, I would not have any problem with that. But I thought I was pretty clear. And look, I went back and looked at the ex parte, and we can talk about that later at the evidentiary hearing. There is evidence that Ms. Budnick presented that Santos was at some of those visits. And I know you may dispute that, but again, I think it's pushing the envelope. I am trying to be sympathetic as I'm ethically allowed to be. But at the same token, the court sort of moving all the lines. Most people don't get a domestic violence restraining order and 6 months later or 3 months later come back and ask to have the presumption lifted. And the court did that because of her situation, because of her pregnancy. But yet, here we have, still feel sorry for me because I'm going to Texas and all of these people are coming to my location. I understand that. But that's the same token. I was very clear regarding Santos. And I think the courts...
Then Bree's attorney, but is the court to the point?
The judge, can I finish, please?
Then Bree's attorney, oh, sorry.
The judge, but by the same token, the fact that there is a representation that W was at the house with Santos's family is quite concerning to this court. It really is. Because I think it's an end run around to the court's order. And maybe the court should have been harsher on some of its earlier rulings. You should have. She took the child to California in contradiction, I think she meant in contradiction, of the court order and requiring law enforcement to respond, and then got a domestic violence restraining order issued against her. And then when there was a representation that she was pregnant, the court tried to work around and try to mitigate the impact of the travel. And then the court would have thought, we would have had a stellar report card from today where the court would seriously consider lifting the prohibition against Santos, but the prohibition against her only traveling to Texas. And unfortunately, there is enough. There's enough there right now that says to me, I'm not comfortable doing that right now. So, look, she wants 2 weeks, and that whole time I'm supposed to sit here and believe that Santos will not be there for 2 weeks? I don't believe it. I'm going to be frank, Miss Olson. I don't believe it.
Then Bree's attorney and the court. So your comment just moments ago that they presented evidence that Santos may have been at some of the visits is the evidence that you're referencing that they presented in the denied ex parte, or what Ms. Budnick had orally presented today about the December visit. I just want her to be able to hear the basis of where the court is coming from.
The court. Well, the ex parte was denied because it wasn't immediate danger. That's why the ex parte was denied. The evidence is there. It was submitted. And I think Miss Budnick's point of view, it could have been presented. It wasn't. I'm not saying, this is what I'm saying. She's asked for a continuance because there have been all of these allegations. You have strenuously objected to all of them. I'm not saying I'm going to, but I'm saying there's enough there. Right now, it's sort of unrebuted evidence. We're still going to have an evidentiary hearing for you to rebut it. But there's unrebuted evidence that Santos was in that area, that Santos was in a visit, that W was at Santos's family house, and right now, that's unrebuted.
Then Bree's attorney, that last one was just brought up today orally by Miss Budnick. We did rebut the allegations that Santos was there, saying Santos was not at the visits when W was at the Airbnbs. We've openly admitted, yes, Santos did travel to Texas with me and went and visited family and friends while I was there, because, of course, he's going to travel with his pregnant partner to help me with all of that stuff. So that was our rebuttal is to admit, yes, Santos traveled with me, but that's not a violation of the orders, and especially considering he has business, figuratively and literally, in Texas because he's from there. So it's not like he's going with her to a place where he has nothing else to do. He was born and raised in Texas. He has family and friends there, and an actual business to do in Texas. So that's what the allegations were, specifically to the ex parte. There was no actual evidence, let alone clear proof, that Santos was at any of the visits, which is the court's order.
The judge, I got back to the spirit versus the letter. Does your client deny? Bree, the court, let me finish, please. Does your client deny that W was at Santos's family house? Bree, I took him to see my parents-in-law. Yes. And his future cousins. Absolutely. It was a holiday. I'm sorry, you never said this before, but I never thought anything was wrong with that. And there was nothing in the order against letting my son see his future, what would they be, grandparents-in-law? The judge, look, there's the thing. Bree cuts her off. Bree says, then we're not left alone. I'm always with my son. The judge says, so you didn't leave? Oh my God, she's fucked. I mean, it doesn't say that on here at all. Sorry. Bree says, mind you, remember you guys, they sweared her in under oath. I never left. I didn't know that was even what was being said right now. I've never left my son. I took my son to see my fiance's family, yes, but I would never leave my son alone with anybody.
Liar, liar, pants on fire.
They already provided the court or the police documentation that she was not there. Okay, so the judge. Okay, so I guess the bigger issue. This is the court's issue, and we're running out of time. The court was pretty clear about the prohibitions of having Santos around and the reason for having Santos around. So you have people around, supportive family, and people live close, and people who can travel with you and things like that. And yet, there's been this, there wasn't a prohibition on Santos traveling. There wasn't prohibitions on that. There was no prohibition on this. And we keep sort of chipping away. And the bottom line is, Mr. Giese, which I know you want to rebut later on, I will give you an opportunity, Mr. Giese. The whole purpose of the court issuing the DVRO was that Santos, on film, issued a threat towards Mr. Giese, and that there was, and I was very clear, look at the transcript. I don't see a connection with Miss Olsen. I don't see a connection with Miss Olsen. Oh, I see a connection with Miss Olsen. And when I found the connection with Miss Olsen, whether I don't know if it was a directive or endorsed or whatever, then at what point the court said that was enough. And so much of it had to do with the threats that Santos, the diss track, and all of that. And so it just seems like what you're doing, just respectfully, you're asking the court for something, believe it or not, that's kind of unusual. To say, you can ask your attorney, and you can ask Ms. Budnick also, when you issue a DVRO, it's rare that 4 months after the DVRO restraining order is issued, the person against whom it's issued is given an opportunity to rebut it. It's very rare. And the reason why the court did it is because I recognize the situation you're in and the pregnancy at the fact that was Santos's child, and giving Santos and I said at some point it's inevitable, but I said it now. And the fact that it just kept, like the envelope kept being pushed back and pushed back. To Miss Fonseca's question, am I making a finding? No, I am not. But what I'm saying is, you're asking me, is we sit here today for the presumption to be rebuted absent an evidentiary hearing or absent a subsequent evidentiary hearing. Basically, any RFO is still an evidentiary. I'm still going to get evidence. I've heard testimony from her. I have declarations. I've seen videos. So any hearing, any RFO hearing is still an evidentiary hearing. I've taken evidence, but if you're asking me, as we sit here today, based on the evidence before me, to lift the presumption, the court is saying no, for the reasons I've said. So what I'm saying is just, am I making a finding either way? No. I'm just saying, based on the record before me right now, and the video I just saw, and much, and look, again, the reason why the court set the hearing before today is because I thought she was going to be in a very tail end of her pregnancy, and I recognize the difficulty she would have in traveling. And so I was trying to accommodate that. The goalpost has been pushed back further. So there's not much of prohibition necessary against her. Can certainly travel to Texas. Amen. That's what we're saying. And so I'm just saying, right now, I'm not ready to do that. I was seriously considering it, but there were some things I learned today that were very troubling. That video is troubling. Look at the end of the day. You know, you guys aren't going to listen to me because you make too much money on TikTok. But your behavior, both of their behavior, is not the ideal behavior one would expect of parents. And one would hope, as you bring a new child into this world, that you start to change your behavior. I mean, that goes back to the issue of the parenting classes. You know, how did you behave? How do you behave? Who do you decide to surround your children with? Who do you decide to be the partner of your children? How do you behave as an expectant mother? Those are all the things that hopefully one would learn at a parenting class. And so, you know, they're going to keep making their living talking about each other and posting on the internet. And I get that. That's how they make their living. But that doesn't necessarily mean that I can't consider all of that in the determining whether they should have substantial custody of their child. That's absolutely a factor. Did you hear that, Bree? You keep telling me that none of this matters over here on TikTok. She just said that's absolutely a factor. Listening ears. Anyway, sorry. It's their behavior and how you know that impact their ability to parent. So I'm not trying to be unsympathetic to her or of her, but you know, she's made some decisions between now and the last court hearing. This is all the judge speaking, guys. I mean, I'm not asking for an award, and I certainly don't want you to thank me, but I think the court really pushed the envelope a little bit in trying to accommodate her for her situation. And you know what? Shame on me, because I think there have been developments since then that show that maybe she didn't hear what the court had to say and what the court's concerns were. And maybe I was too lenient. And now here we are. You guys, I think the judge was listening to the SOC gang. We said that. SOC gang said that. You're being too lenient. Sorry. So, I don't know. I mean, I set today's hearing because I thought she couldn't travel, and then she went to Paris. So, what are we going to do? Bree interrupts again. Oh my God. Her and her attorney are perfect. Bree, I only went to Paris one time. I don't go every month. The court. I can't.
Sorry.
The court or the judge. I think you're absolutely missing you're missing exactly everything I just said. What I said is, and I'm going to say it again, I set this court hearing early because I was trying to accommodate you and what was represented to me, your inability to travel. And then you traveled internationally. Bree, my circumstances have changed between that time. The judge, okay, I understand that. I get it. But then there's no expediency for me to make a determination today. Bree, okay. The judge, you understand that? Bree, yes. Hold on, I'm going to take a pause right here before I go on. I now understand exactly why Bree said that she has issues in her pregnancy, that she had high-risk pregnancy.
Yep.
Because the judge is saying right here, I was going to lift it because you were pregnant and you weren't going to be able to travel, so I was going to lift it. That is why Bree is going to come back here in a little bit and say, oh, but I have high-risk pregnancy, I can't travel. And the judge is like, I don't give 2 fucks. You can get 10 minutes. Anyways, I'll finish. Okay. You understand that, Bree? Yes. The judge. Okay. I pushed up today's hearing to try and accommodate you. The reason for that accommodation, sadly, and I apologize that happened, is no longer present, okay? You can still travel. And so you could still travel to Texas between now and the next court hearing. Bree, okay.
Then
John's
attorney.
Oh, sorry, go ahead.
Sorry. If the court...
The judge, okay. And I guess I just need to make it clear then. I mean, look, let me ask you, Miss Budnick, do you have other videos of separate instances? Ouch. That you're going to be showing at the next court date? Showing at the next court date of what you claim could be domestic violence between her and Santos?
Then John's attorney, I do have other videos or recordings, and I think it would be maybe helpful to avoid going back and forth on this issue on the 2nd if we set a date by which I provide those to Ms. Fonseca.
The judge, but do they involve allegations of yelling and screaming?
Then John's attorney, there are allegations of yelling and screaming and other abuse by Miss Olson.
The judge, such as?
Then John's attorney, other examples of physical violence or accusations of physical violence.
The judge, such as?
Then John's attorney, such as pushing, shoving, more of the similar to what we watched.
The judge, okay. Look. Was that video troubling? Yes. Was it not so troubling because you were not, again, I understand why you did it. It's a different situation. If you had been pregnant and in that situation, that's more troubling. Why is that more troubling? So it's okay. Yeah, I'm just having a pain right here for some reason. What? So is it okay then if you're not pregnant to do that? I'm so confused. I'm so confused on what's happening.
It's bad either way. You shouldn't be putting your hands on your partner, pregnant or not.
Yeah, I'm confused as to why she's saying that. It's almost like she's given her a green light. Anyways, if it was an isolated incident, that's one thing, but you're young, and frankly, you've conveyed some judgment decisions as it relates to your parenting that causes this court great concern, specifically taking your child to California and not turning your child over. And remember I said to you in court when you said, I have these advisors who told me not to listen to the sheriff. And I don't know if you remember what I said. I said, you don't need to listen to those people anymore because they're not your lawyers. And they could have gotten you seriously hurt. And you were very lucky that they didn't. And that's nobody else. Oh, and that, what? Sorry. And that nobody else was hurt. Because when you defy law enforcement orders, things can happen, okay? And my concern, just so you understand, is I think you have a volatile relationship with Santos. Amen. Someone said it. I do. And to that extent, that there are other evidence of that causes the court's concerns from overcoming the presumptions because the domestic violence restraining order was granted based on verbal altercations and threats. Not physical violence, it's still domestic violence under the restraining. But if it goes into the area, now we don't just have verbal threats, but we have physical violence, even if it's with nobody else. That causes me concern for W's perspective in terms of what kind of environment you're putting W in. So that's what the court's concern is. And I guess, you're very smartly, I don't know why I keep saying that. And I'm not mad that when I say something and you disagree with me, and then you respond and you advocate for yourself. I think that's great and good for you. But you're missing the bigger picture here. You have to make better choices. And I don't think you've made good choices. And I need you to make better choices if I'm going to seriously consider giving W to you 50% of the time. And I think you could still make those good choices and still earn the living that you're earning. But I saw a video during the domestic violence restraining order with you on the bed with other people and vaping and all sorts of other kinds of things with W. And that disturbed me because I didn't think it was a good choice. You could still monetize on TikTok and all that with W in the picture without exposing him to those things that put him in danger. And that's what I need you to focus on. To focus on being a parent and a safe parent. And if you have a relationship with somebody with whom you have a volatile relationship with that necessarily puts your child in difficult and potentially in a dangerous situation, and that's what I need you to think about. So,
Hey, let me read a little bit because you've read a lot.
okay.
I'll take over.
Okay.
So this is still the judge. So to go back to Miss Fonseca's original point regarding the class, you can finish a class and pass with flying colors, but the proof is going to be in the pudding as to whether or not you learned anything. And my sense is a good parenting class is going to tell you don't be fighting and arguing with a partner of your future child and yelling and screaming and pushing because that's not good parenting if that child is exposed to that. So I just need you to hear me. That's what the court is trying to figure out. Then Bree's attorney, as to the importance of the safety and general well-being of W's environment, if at the next hearing they're going to be presenting evidence to the effect of what Miss Budnick's described, are we then allowed to present evidence regarding the resident of John's home and his friend Chris? The judge then said, absolutely, absolutely.
Hold on. I'm sorry.
Then
Where are they getting this info? How did this get turned? Where are they getting the information that Chris is living with him? I'm so confused.
he stayed with him for like a week or two when he first moved and bought his house in Texas.
Yeah, I'm
But that was
so
a long time ago.
yeah. Oh, I'm good. This is a very typical migraine for me. This is a very typical migraine that comes on and just hits me right behind the side. I'm good. We're almost done. I'm okay. Thank you guys though so much. This is very typical for me. I'm sure scary. I'm sure scary seeing it come on like that, especially with what my son's going through. But this is a very typical migraine for me. It just feels like something just stabbed me in my eye. It'll go away. But love you guys. Thank you. Okay.
Okay, and then Miss Fonseca, Bree's attorney. Okay, because there's been threats of physical violence, specifically naming Santos, made by this person repeatedly, including that exact day of the hotel incident. Because, again, John was at the airport streaming, not at the hotel. And that was the same day that Chris threatened to curb stomp Santos and knock all of his teeth out. And this is allegedly somebody that has been living in John's home with his mother and W for several months. Then the judge, absolutely, because what the court is going to determine is what is the best custody and visitation schedule for this child with both parents. And now you've heard me. I've said it before and I said it again. They both have great room for improvement, including Mr. Giese. I saw a bunch of videos that also caused me concern about Mr. Giese and his behavior. And frankly, I think he relies on disproportionate amount on his mother to raise his child. That came across too. And I don't believe that Miss Olson has the same ability. I mean, when she's on with W, it's all her. I get that. Absolutely. I don't want this just to be all on Miss Olson. But right now, she has to rebut the presumption. So, absolutely. All right, let's do this. I don't believe right now, at this point, there is enough. There's just too much out there. So, what did we say? April 2nd, Michael, the clerk? Yes, April 2nd. Then
Okay,
the judge?
I can go back if you want me to, because
Okay.
I think you're about to have to pick up a bunch here in a second. Okay. Do we have a backup date in case we go over, or let's just see? The clerk, no. Judge, okay. Here's what I would like everybody to do. You're both really good advocates, and I've said my piece. Let's just focus on the evidence. When I ask you a question, give me a simple answer. Don't give me the whole history because I want to make maximum use of our time. I'm going to continue the evidentiary hearing on April 2nd at 1:30. Right now, I'm going to continue the visitations in Texas, the same as it was. Let me ask a question. I know I ordered that Mr. Gacy be informed of where the visitations are. It's been, and the reason for that so many times needs to continue is what, Miss Budnick?
Then John's attorney, So I think the issue is that we continue to have concerns about Miss Olson leaving the location where she's supposed to exercise visits. The order was clear. It was to be Dallas and the surrounding counties. She just admitted that she brought W to San Antonio, Texas, to her partner's family's house.
Bree, I said his family's house. Well, I don't know why she keeps interrupting. Wow. I said his family's house. The judge. Okay, stop. Miss Olson, same rule for you. You don't get to interrupt. Oh my god. Bree. Okay, sorry. I'll speak after. This girl. Oh my god. The judge. Okay. I can't.
Then, John, you should be letting your lawyer speak for you. That's the point of an attorney. Anyways, oh man. Okay, John's attorney. So that would be my point. I think, given the concerns of removing the child from the location of the visits, I think she is not telling Mr. Giese where the visits are occurring. There is really no way to ascertain if the orders are complied with. I think it creates room for Miss Olson to say, well, I don't have to tell him where the visits are. I'm going to go wherever I want, and I can hide it because I don't have an obligation to share information. And I think it is beyond just the issue of the restraining order. I think it's a courtesy for parents to know where their children are staying overnight. I think if there's an emergency in Mr. Giesey's household, it's nice to know where his child is or vice versa. So I think in terms of just good co-parenting behavior, they should know that information. But I think it's also given the specific issues with Miss Olson and removing the child from where she's supposed to be located. I think that it's imperative that we know at least where the child is supposed to be in case there is another issue of the child not being returned or brought somewhere he should not be brought.
So before I go into what the judge says, I hope that they bring up the fact on her first visit, I believe her first day at 2 a.m., she messaged both John and Mama 2K to come pick W up because she had an emergency to run back to California to that had to do with what? Santos being out with, she thought being out with another girl or whatever. I think that is such a huge piece to this that I'm not hearing about in the court documents. You know what I'm saying? And I think that that's important. And then she just responds later, okay, well, hours later, okay, well, never mind. Well, then they're like, when they wake up in the morning, I'm sure they're like, well, what the fuck? What do you mean, never mind? Is everything okay? And then no response. You see what I'm saying? That would be a huge reason why I would want to know exactly where she is. And she does not have the support system that John has. Remember, she's in California. All of Santos's family is in Texas. All of Bree's family is in Texas. They don't have like a brick and mortar job to do in California. As a matter of fact, she just testified under oath that all of Santos's business is in Texas.
Yep.
So there's no reason for them not to be in Texas. But anyways, besides status in Lancaster. Okay, so the judge says, why did we do surrounding counties in Dallas? I'm trying to remember.
Then John's attorney, Miss Olson had requested that the visits not be limited to Dallas just because sometimes she may want to stay in like a less expensive location that's more convenient to an airport or something else that she wanted to do that may not be exactly in Dallas. And there was an issue with when the supervised monitor was in place. The order was very clear visits are in Dallas. And there were occasions where she wanted to go, like an aquarium in the neighboring city. The reason you limited it to the surrounding counties as opposed to the state of Texas is the state of Texas is so vast and so vague that I think that was your way of giving some freedom while still keeping some control over the location.
The judge. All right. Unfortunately, we only have 3 minutes. So let's do this. I'm not going to change the orders. I'm going to keep them the way they are because I don't want there to be a lot of confusion. Let me be clear. I understand that I don't know why you need to travel with Santos. That's your decision. He's your fiance. He is not to be present at all during W's visits. Do you understand that? Bree says yes. May I say something? The judge, if your attorney thinks it's a good idea, her attorney, dumb as shit. Oh, sorry, that's you. Not you, dumb as shit, but her attorney. Sorry.
Then Bree's attorney, it's okay. Yes.
I'm not an attorney, but if I was, that would have never happened. But listen, I think she's done with her attorney, but here we go. I just wanted to say, because there's a lot of concerns of now there needs to be more restrictions on the next visits until the next hearing. I'm on medication. I'm not going to say what it's for. Stop it. You could have picked something anyways.
Yep.
So I need to be near my OBGYN. So I'm not going to be doing my visits in Dallas these next few months. But I can request FaceTime calls. It's just, that's really important to me to stay near for my current pregnancy.
Then Bree's attorney, and this just happened earlier this week.
The judge, okay, Bree. Yes, so my OBGYN actually just prescribed me to start that now that I'm in a new trimester in my pregnancy. The judge, okay. And they do have concern. I'm not going to say what she's saying she has. Concern for that. So I'm on hold on. Did she just lie under oath again? Listen, I'm just going to say migraine because I don't say what people have. I don't release medical information, okay? She just said yes. So my OBGYN actually just prescribed me to, oh wait, hold on. It's up here. I'm on medication for an issue with pregnancy. So I need to be near my OBGYN. I'm not going to be doing my visits. Okay, so she didn't say she was diagnosed. She was just on medication for it. That's not how this works. That's absolutely positively not how that, but anyways. Okay. Yes, my OBGYN just prescribed me to start that now that I'm in a new trimester of my pregnancy. The court, okay. Bree, and they do have concerns for this issue. So I'm on medication for that. The court, all right, well, if they clear you to travel, he can come with you if he needs to help you, but he can't be present. I didn't lift that, but earn the right to lift it. Don't play games. Bree, I'm just saying, I wasn't going to do my visits. These visits that are, Jesus Christ. The judge, I need you to, I got a minute left. So if you do visits in Dallas, he can accompany you. He needs to leave. He has family in Texas. He needs to leave during the visitation. I'm not extending the visits in terms of length. You're going to be 1 week at a time. Same schedule. If Santos wants to accompany you, that's on him. He's not to be present at the visits. If everything is great and there are no more outbursts and no more visits, no more videos, and depending on what's on the video, I'm going to seriously consider the request to lift the ban. I am. But let's not push the envelope now, okay? He's not before me. I have no jurisdiction over him. You have to understand, I think you both do. Every single thing you do online, which is your life, the other side is going to find. So the more fights, if there's more pushing, if there's more drunken altercations, I'm going to find out about it because Miss Budnick is going to show me. And I am concerned about the volatility of your relationship. I am. But that's your decision. But I also, W is before me. And I have to protect W. And putting W in a volatile environment isn't necessarily good for W. Maybe you and Santos need to go to get some counseling. And maybe you need to work on how you don't trigger each other and how you can be the best couple you possibly can for your new baby. and hopefully for him to be a step parent to W. Let's not hope that. That is the hope, and that is the goal, especially now, not that you're engaged. Or I think that's supposed to be now that you're engaged. But your new baby is not before me right now. W is, and I have to be protective of W. So I'm going to change the custody order, so I'm not going to change the custody orders at all. What I'm going to say, because I know we're going over, this is a standing order, and I know you both work well together and you're great advocates. Send each other everything. Let's not, as soon as you get it, send it to the other side. But I don't want to have at the next hearing as well, I didn't get it, I didn't get that. So I'm going to say that the court is not going to consider anything that wasn't provided to the other party. But let's just say all documents, all witness lists, all exhibit lists have to be exchanged no later than March 16th. We just went over those yesterday. That is up on my FYP. Oh my God, my YT if you haven't seen it. All the parties are to meet and confer regarding any evidentiary issues, etc., regarding by March 30th. I don't want any of these mornings of supplemental pleadings. I am not going to consider them. I'm going to strike them.
Embree's attorney, and you didn't say exhibits, but you meant also exhibits, along with the list, right?
Oh my God, was she one of those teacher pets? I know that that's part of it too, but oh my God. Yes, exhibits and the list. And as soon as you get something, send it to the other side, okay? And we'll see everybody on the next court date. And I'm going to keep the orders, the custody orders as is. If she wants to exercise them, great. If not, there's an option for FaceTime. Have we set that up?
Then Bree's attorney, no, we don't have an order. Then John's attorney, they have done some FaceTime. We're happy to accommodate.
The judge, okay. Why don't the attorneys meet and confer and set up at least weekly FaceTime visits with W, okay? And has Mr. Giese done a parenting class?
Then John's attorney, he did a class earlier in this case. I don't have an issue with him doing another one if the court wants him to.
The judge, I think you should.
Then John's attorney, okay.
John, can I ask you a question? The judge, sure. You said something about my mom. I just want to be clear so I can understand where you are coming from to correct it, if it is concerning. You said how I work and how my mom helps me may be concerning, or I don't know if I heard that correctly. The judge, I didn't say concerning, sir. I didn't say concerning. John, yes, ma'am. The court, I said that you rely very heavily on your mom to raise your child. That seems to be the evidence from her testimony and other things that came forward in the court. And what the court was saying is, in comparison to Miss Olson, I understand that she doesn't have, at least right now, I guess her mom is moving in, but I haven't seen any evidence today that her mom did play such a heavy role. Sorry, I know I don't usually do this. Why is that John's fault? How is that a dig on John? Because mind you, she's choosing to live in California away from all of her family. Why is this a dig on John and Mama 2K? Listen, Judge, you may not be my homegirl. You may be Bree's homegirl, but don't fuck with Mama 2K. SWAT gang round up. We're coming. Let me be quiet. Let me shut up and not fuck up their case. That's disrespectful. Okay, sorry. Let me move along. At least right now, I guess her mom is moving in. Bullshit. She's been saying that for 2 years. But I hadn't seen any evidence today that her mom did play such a heavy role as is related to raising W. And I guess the court's concern is I want you both. Part of the reason why I want you to take a parenting class is because I also saw some concerning evidence in the videos and other testimony of your behavior as is related to W. And also, I think you both would benefit from taking a parenting class. I can't prohibit you guys from posting about W. And I think it's kind of ironic, Miss Budnick, there was a lot of statements about and testimony, your client, about how Miss Olson posts about W, but your client does the exact same thing. I mean, they both post about W. I don't like it. But there's nothing really I can do about it other than saying they really need to think long and hard. But I think a parenting class might help you put that into perspective. That's what I meant in that regard. You absolutely get to rely on whoever you want to assist in raising your child. And your mother seemed like a wonderful help. She is. We love her. And I have nothing negative to say about your mother. Amen. Okay, you're back on my good list. You're very lucky to have her in your life. Amen. That was my point, John. Yes, ma'am. All right. We'll see you guys on the second then. Thank you so much. The clerk, 12 parenting classes. The judge, yes, 12 parenting classes. Whatever standard is. We'll see everybody on the second.
Then Bree's attorney, is the minute order serving as order after hearing?
No, it is not. You guys are to prepare one.
Then Bree's attorney, who?
Who wants to prepare? Whose motion was it? I guess it's yours, Miss Fonseca.
Then Bree's attorney, 3044.
Yep, I think.
Then John's attorney, thank you.
The judge, thank you.
Then John's attorney, have a good night.
And then they put up this is just the, that it was done by the thing. Wow. What do you guys think? I mean, I grasp, again, the judge has to be non-biased until, a 3044 is the domestic violence order. That's what that is. The Bree's attorney is trying to get it lifted. John is requesting for it to be extended for 5 years. If you guys missed yesterday's hearing, we went over all of their evidence list, their witness list, absolutely everything. I did a quick snippet, but the whole thing is on my YT if you guys want to watch it. Based off of that, yes, thank you so much to Bailey. Bailey's always amazing. The case to me is a slam dunk because John has on his evidentiary list probably 40 something videos since this of DV. Remember when Santos was on with his black eye and you see her punch him? The video of her saying, yes, I do hit him. You got to abuse your man every day to keep them in line. All of that has been put in. The only evidence Bree has put in was that she started a parenting class, that Santos started a parenting class, all of the minute orders that have already been put in, including this one, and then basically a whole bunch of stuff about Chris Different, which I don't understand. And mind you, yes, Chris Different said some shit about Santos, but mind you, it was after Santos came into Chris Different's live, starting shit with him. But what does Chris have anything to do with any of this? This is the last case. It seemed like when Bree put in her paperwork, it seemed like she was fighting for custody and visitation of Santos. Now it seems like she's fighting for custody and visitation of Santos from Chris instead of from 2K. It's confusing. She does not have a case. At this point, I would say save you some money. You clearly are hurting up for money. Save you some money. Talk to John, or through your attorney, talk to John. And before anyone says, oh my God, you should be advocating for, listen, in the very beginning, I was advocating for Bree a lot. I have said from the beginning, I want Bree to turn her life around and become the mother that W deserves. So I never advocate for absent parents. But what is worse than absent parent is what? A popcorn parent. A parent that pops in and out of somebody's life. Right now, she is not ready to be a mother to W. She's ready to be a mother to Santos, and that's it. And that's even questionable, right? The best thing she could do right now is go through her attorney, tell John, I'm not ready. I'm not in the best position for baby W. And I want to be the best mother that baby W can have. And I'm not in that position. And I have a new baby coming and I have to prepare for that. And I know that sucks, that that's going to take away from that. But I promise you, I'm going to get better. You have done a fabulous job. And I appreciate that so much. I'm going to step away and I'm going to get better. When I do, can you do it? Can you send me, like on his birthday, send me a picture, send me a letter, maybe every quarter, send me something of an update on how he's doing. And when I'm better, at least allow me, at least open the door to let me have a conversation with you to see if I can come back in. Now, if she was a great mother, that's exactly what she's going to do. Because she's not going to win this case and she's about to lose a shit ton of money. This judge is going to be pissed when she sees all of this evidence. This judge is going to be pissed. And it's going to be what's best for Baby W. But what do I know?
It goes to show who actually was listening in court and who has taken the advice from the judge, who has tried to turn their life around while still trying to make a living on social media, and who hasn't.
No, Chris is not on the witness list. And not only that, you guys, in here she says that she can't travel. So she asked for FaceTime visits. She's not even doing her FaceTime visits.
She can't even pick up a effing phone.
It's crazy. The judge is going to be, trust me, the judge will be pissed. My YT is the same as my, what's this called? My TikTok page. There's also a link in my bio as well. How do we know? Because it came out. She said it. I think she said she's done 2 visits or 1 visit. Yeah, no, I think she's done 2 visits because she did 1 visit and she said, someone asked her how her visit went today. This was a while ago. This was back in January. And she said, it was good. I got to see John today. That's what she said. Then she missed several visits. I don't know how many because I don't know how often she gets to visit. Then somebody said, well, when do you get to see W next? And she said, I think it was like the next day or that day or something. And she said, something about, or they said, how do you like the visit? She's like, it's really good because John's there and he just kind of plays with them, so I just get to watch the both of them. Something along those lines. I can't remember word for word. It's been a while. But yeah, she says she's the one that said that she hasn't seen them. I'd have to find the clip that I was sent to find out how long.
Wasn't it in some documents just that were released from John's attorney saying that she hasn't shown up and she hasn't done any of her FaceTime visits as well?
Yeah. Yes, I will. Depending on how my mic, oh God, it's 10:32. Depending on how long it takes to download, I just took my migraine medication. So as long as it lifts, I will get it up tonight. If not, it'll be up first thing in the morning. It was in the documents. I knew I read it, but I also remember getting clips from her stating it though, because that's how I knew that she was excited about John being in it. So you guys, I know I've been saying this for a while. I have faith in this judge. I think, especially now that if she was that pissed about seeing that snap or that wasn't that a chap snap of when she just pushed Santos, the rest of them, please, it is wraps. Again, and tomorrow, if you guys want, I can go back over both of their evidentiary lists and we can compare them. I can do them like side by side. We can compare them and we can see. But yeah, I fully believe. Oh my God, did I say that wrong too? Shit. What is it again? Chap snap? No. Well, whatever. India, chap snap, whatever. That's just I got my own terminology over here. I just be renaming bitches and everything, okay? Speaking of, Snapchat, shit. Speaking of, it's so late. We'll do, are you guys going to be mad at me if we do Wavy and India's things tomorrow? Angie took India and went to the chaps. That's her name, right? No, what's her name? Ireland. Oh my God. Why do I want to name her India? Listen, you guys know what I'm talking about. So are you guys cool with that? We can do it tomorrow. And I'll start with that. Lawyer may have, I don't know if he was live today. He may have already went over it. Oh, speaking of, if you guys are not on my YT. See, I know her name because I forget. Look what I did as their... It's not very often that I make pictures or whatever they're called because, well, I typically don't know how. But look what I did on the video I did of theirs. Oh, wait, hold on. You can't see it this way. Look at the... I did the map of Ireland for her. I put a picture of Wavy and Issa, and I just put the little map of Ireland for her. But anyways, they're all on here. Oh my god, we are 1.5k views on this is the one that does yesterday's thing. So tomorrow we'll do Wavy and Ireland because it just popped up the text messages that Ireland has been sending to Wavy. And oh my god, not gifting 2k tonight. Oh my god, let's warn him. Shit. It is not worth the money. That headache is not worth the money, okay? Anyways, I apologize that I scared you guys with my migraine. That's how they come on. They sit back here, like sometimes for a couple hours, sometimes for a couple days, and then out of nowhere, it literally just feels like I'm just being jabbed in the eyeball with a knife, and that's how they hit. So I apologize that if I scared anybody. I did not mean to. But I took my medication. I'll be fine. I'm gonna lay in the dark, in the cool, and I will be good. So I love you guys so much. I will do a quick recap video and post that on my TikTok in case anyone needs it. And then I will download this right now and get it posted up on YT as soon as I can. Shout out to Sammy. Sammy, you are the GOAT. She always makes sure we have all of this. So shout out to Sammy and huge shout out to Bailey. Listen, you guys, it is not easy reading these court documents. First of all, we're in front of 2,000 people reading. Just start there, right? And then it's confusing the way that they have it done and whatnot. And then when people get to all of that, you know what I'm saying? So Bailey, I always appreciate you. And Bailey, I believe, has done absolutely every single one. So it's good to have it consistent. And so I appreciate you so much. So thank you for always being willing to step up. And you guys, I messaged her. I found out about this at my grandson's basketball game. So not even an hour before we came on. So it's not like she even had any notice, nothing. And then you guys heard her, she was on live and then said goodnight to her. You see what I'm saying? So we appreciate that over here. And it's late as shit. Okay? So I love you guys all so much. Thank you guys. We're at 1.1k heart me's and 611 taps. You guys are freaking amazing. I love it. I'll message 2K and let him know. So I love you guys so much. I will see you tomorrow. Have a good night, guys. Bye.
Bye. Thank you.